There we go. Good morning. This is the New York City Board of Standards and Appeals review session for August 9th, 2022. There is no public testimony during the review session. The first item is the BZ calendar, continued hearing items, item number 26, 2016-4463 BZ, 6202 14th Avenue, Brooklyn.
Okay. This application was last heard on May 24th. At the last hearing, the applicant had responded to the board's comments. The board was waiting for a DOT sign-off, and I believe the applicant has submitted a revised EAS, and we received additional comments from DOT as late as July. And in response to DOT's comments, the applicant has submitted a signed commitment letter. And the school is basically agreeing to respond to all the DOT comments regarding school safety, that the school safety, including funding new traffic signals at the intersection of 14th Avenue, 62nd Street, conducting a warrant study of the intersections. School will also prepare a builder's pavement plan for all corners and upgrade the pedestrian ramps, and also to upgrade the pedestrian crossing at the corner of 14th Avenue, 62nd Street and the northwest corner of 14th Avenue, 63rd Street. Did I leave out anything?
Yeah. Jella, do you want to jump in? You want me to do it? So there was a few more questions, but Jella, go ahead. You can do it.
Oh, there were some comments issued on Friday, August 5th, some additional comments. Just some requests for student surveys, some information about the all-way stop control, and some requests for the illustrative language on the plans, and some minor corrections. So the applicant has responded to these on Friday pretty quickly. After they received it. So DOT has been working on a draft sign off, but that is not in hand yet. So we will keep you posted on that.
Do you think we can, it's something that DOT can provide today?
I believe they're aiming for that.
Yeah. Okay.
Yeah, so what, if Madam Vice Chair, if I could, we discussed this internally, what we'll do is, if by the time that the public hearing begins on this case, we have that sign off, we'll alert you. In the event that it's still a work in progress, perhaps we could put it at the end of the hearing calendar to give DOT an opportunity. We can review it, share it with the board, and make a decision.
That's exactly what I was going to suggest. That's perfect. Thank you, Jella. Thank you, Carla. I have no additional comments on it. Commissioner Otley Brown?
I have no additional comments.
Commissioner Shetta?
Nothing further from me, thank you.
Commissioner Shibeta?
No additional comments. Thank you, Chair.
Okay, and Commissioner Yoon?
I have no comments, thank you.
Okay. Great, thank you.
Go ahead, may I go on?
Yes, please.
Item number 27, 2020-71 BZ, 166 Coffee Street, Brooklyn.
Just give me a second. I'm going to pull up the drawings. Okay. So we got two submissions on this, one from July and the other one more recently in August, I think last week. The application was last heard on April 12th. This was the initial hearing that we had. The board believed at that time that most of the comments that the board had were, they were related to proposed development and meeting the neighborhood character findings and financials. So the applicant has revised the plan and the analysis in response to the comments that were raised. We have a revised proposed plan where the applicant has increased the front yard depth to 15 feet and providing a 30-foot depth Previously, there was a much deeper rear yard, and the applicant was proposing to retain a much shallower front yard. So the applicant has increased the front yard depth, and the building has been pushed back to maintain a 15-foot depth and having a 30-foot rear yard depth. So I'm satisfied with that proposed change. In terms of the neighborhood character study, the applicant has revised the study to add FAR, floor area, and height study. And the proposed floor area, as the analysis indicates, would be in range of the existing condition on the block. And the height of the building will also be consistent with the existing residential context of the neighborhood. So I was satisfied with the revised neighborhood character analysis. With regards to the revised financial, as directed, sorry. And as of right, one story, since it was determined that the existing building is an obsolete structure, it was directed that the applicant consider an as of right full lot coverage commercial building, and a narrative was asked to be provided. I think this was a recommendation made by Commissioner Otley Brown. I will ask her to speak to it. And so far, from what I've reviewed, it seemed reasonable, and basically the applicant is stating that an as of right one story also results in an infeasible outcome, and therefore, so I'll let the applicant speak to that. In terms of common ownership, the applicant has provided clarification on the ownership, and it seems back in 1976, the subject lot and its adjoining lots were in common ownership of Port Authority of New York and New Jersey, and then city took ownership of it. And after city took ownership of it, these lots, they were sold separately. And board has previously determined that even though the site was commonly held and subsequently acquired by the city of New York and sold separately, it did not constitute a self-created hardships. And I think that applies in this case. So I was satisfied with that. The applicant was also asked to revise the Silliman report, which has been done. And I don't have any other comments on this one. I think all in all, the applicant has met all the findings as I see it, but I look forward to hearing comments from the commissioners. Commissioner Otley Brown.
So in the financials, the reason why the as of right was redesigned was that it was originally contemplated to be 1.5 stories plus cellar, office/commercial building, yet in their statement, they had stated that office would not work in this neighborhood. And so because the costs to build this were elevated because of the extra 1/2 story as well as the cellar, I directed them to redesign the building to be a one story full lot coverage, no cellar, like storage facility, like warehouse storage, because they themselves had admitted that the office didn't make sense. And then I also directed them to justify their costs by using Marshall and Swift, and they did. So they used Marshall and Swift residential class B for the proposed, and this resulted in a trimming of costs for both the as of right and also the proposed, which is what I was basically suggesting. And so now I feel that the financials are actually reasonable, and they are reasonably showing that the as of right is not feasible with a 6.0 cap rate for a warehouse, and the proposed is feasible and the minimum variance. So another question that I had actually had for them was the way in which they adjusted their existing townhomes, which were all smaller than the subject. And they did justify it. They said that while the subject comparables are all smaller than the proposed, they're actually providing for on-site parking, whereas the proposed is not. And so it's kind of like a give and take. The proposed is larger, but doesn't have on-site parking. Their comps are smaller, but does have on-site parking, and they suggest that washes out. And because we really don't focus on financials for one-family homes, I accepted their rationale, although I'm not sure I agree with it 100%. But I figured, all right, let's just close this out because they did prove that the as of right doesn't work.
Okay. Thank you. Okay, Commissioner Shetta.
Thank you, Vice Chair. I did look at the revised submittal for the structural engineering report from Silliman's. Although I didn't have significant comments on it during the last hearing. I see that they revised the report by providing a key for the photos. I still agree that based on the photos they submitted, the building is in very bad shape. And I would even say that it's not feasible to fix it. I do believe that they met finding A, the uniqueness finding, and the rest of the variance findings. I don't believe that the proposal would impact the character of the neighborhood. In general, I'm satisfied with the applications and ready to move it forward. Thank you.
Thank you. Commissioner Shibata.
Thank you. I want to thank the applicant for his submission. I found it satisfactory. I believe the application meets the findings, and I have no further comments.
Commissioner Yoon.
Thank you. I have no comments.
All right. Next, before I go, Commissioner Shetta and Commissioner Shibata, can you just change your title to add your yeah, and Commissioner Otley Brown. Just add Commissioner.
It was okay yesterday. I don't know what happened.
Well, maybe you can do it.
Yeah, we'll do it.
Okay.
You want me to call the next case?
Next case, yes.
Okay, so item number 28, 2020-86BZ, 15 Parkville Avenue, Brooklyn, was adjourned, as we stated yesterday. So a new date will be set up for that. The next item is item number 29, 2021-40BZ, 157 West 24th Street, Manhattan.
All right, just give me a second. My computer just went on a funny ring. Hold on, just what happened? Let's go on a break. Just give me a break. The screen just went froze.
Wait, we'll wait.
Okay, I think. All right, I missed all that. All right, please continue.
Okay.
Yeah.
Calling again, item number 29, 2021-40BZ, 157 West 24th Street, Manhattan. Oh, great. Here goes my computer now. Oy. Go ahead. Go ahead.
Oh, well, okay.
Yeah, the bottom of the screen is gone.
This has been a tech not so friendly week. So the application was last heard on April 12th. That was the initial hearing that was held. At the hearing, the board had agreed that the uniqueness was met. The outstanding issue was the extent of the hardship and neighborhood character. The board had directed the applicant to revise the financials and modify the bulk, specifically the proposed height of the building. We had directed the applicant to basically reduce the height of the bulk, pack in the bulk, that is to provide a building that is not set back from the street line, but maintain a street wall context, which is predominant along that block front, and then provide a setback and build up. So we have received a revised set of plans in that the applicant is proposing a building that is 12 stories high, 12-story high. The initial proposal called for a 15-story high building, and this reduces the building height from 155 feet to 117 feet, and further reduces the floor area ratio to less than 9 FAR. And that was the other thing we had directed the applicant, was to the nearest residential equivalent zoning district to this end zone was an R9X, and R9X allows a 9 FAR of residential. So we had asked the applicant to reduce the FAR. So by packing in the bulk and reducing the height, it has resulted in a reduction of the FAR also. This also reduces the number of units, though not by much, but it reduces it to 23 units. The applicant also provided a sliver lot building analysis. So if this zoning district was zoned C6 3X or an R9X, and if a residential building as of right were to be built, the applicant kind of showed what kind of imposition the site would have to incur, because this is a it's less than 50 foot wide, and there is a provision in the zoning resolution as specifically applicable to actually residential buildings, that if on a sliver lot a residential building were to be built, it would be not be privy to the underlying height and setback and regulation. Instead, it would have to abide by the sliver lot rule. And that's why in the public hearing and the testimonies that we have received, you would see that the sliver lot has been mentioned. And basically the way the sliver lot would work in this case is that since it's on a narrow site, the height of the building would be the maximum, would be the height that would be proportion to, would be the same height as the width of the street, or 100 feet, whichever is less. In this case, since this is on a narrow street, the street width of 24th is 60 foot. So the maximum height the building can accomplish would be permitted if it were in an R6, R9X district, would be 60 foot high. And the applicant provided an analysis, and that it would result in a building with an FAR of 4. And then the applicant has provided financials, and the soft cost, I noticed, has been reduced. That was one of the asks, and has also revised the as of right financial analysis. So I will look to Commissioner Otley Brown to provide response to that. In terms of the rear yard, when we had asked the applicant at the last hearing, the board had asked the applicant at the last hearing to pack the bulk. The question was, should there be a little bit of a give in the rear yard? And since the rear yard context in this area is very shallow rear yard depths, the board had kind of was okay with it, provided a study was provided. And the applicant did provide a study indicating that most of the rear yard in the area is not very deep. And the applicant is proposing a 15-foot deep rear yard. And this is to basically allow for a deeper floor plate with a street wall building. Now my biggest question with this is still finding D. And I don't think the finding D, which is a self-created hardship, I don't think it has been met. As you recall, there was a BSA variance that was granted in August of 1978 to convert the upper floors on lot 10. Now, lot 10 is the abutting lot, and from an M use to residential use. Now, the resolution of this August 78 grant also includes lot 9, which is a subject lot. And so the board wanted a clear understanding of where these two zoning lots, is it a combined zoning lot? Because lot 10 is underbuilt, and there is FAR that could be, unused FAR that could be transferred. So the question was, what is the relationship of lot 9 to lot 10? The applicant to that and provided certificate of occupancies for both lots 9 and 10, dating from December 1978 and November 1978, respectively. Now, the boundaries stated in the COs are, as I look through it, is consistent with the current tax lots. However, the COs of lot 9 and lot 10 that were issued after the 1978 BSA resolution was adopted, which is August of 1978. So I think the applicant still needs to clarify if the boundaries of lot 9, if it did change after the 1978 resolution, what was the boundaries of lot 9 before the 1978 resolution is what I need to look for. So the applicant should provide a historic analysis using historic tax maps, COs, etc., to confirm that the lot size of lot 9 has not altered all throughout. As I mentioned, the board at the last hearing found that uniqueness was met, the neighborhood character was one of the questions, and which I believe the revised drawings does address it. Financial, we have to hear from Commissioner Otley-Brown. However, finding D is not there, and that needs to be addressed. Point of note, we did receive several opposition letters from the neighborhood expressing concern about the revised proposal. So I believe we will be having a fair amount of public testimony on this at today's public hearing. So Commissioner Otley-Brown.
So I reviewed these new financials, and we had questions previously about the site value and the land sales that were pre-hotel text amendment. And we also had questions about the construction costs. So as for the site value, they could not find any post-hotel text amendment sales, but I think they were using the wrong date, because they say in the financials that there were no hotel sales that occurred in the M1 after December 2021. And they use that as the text amendment change date, but the text amendment actually passed in December 2018. So I think they're looking in the wrong place. So they're going to have to go back and look at the sales in that area again and see if they can find anything post December 2018. And then as for the adjustments, on page 18 of the financial statement, they say that they did a downward adjustment to land sale comp 2 for time since the sale, since the text amendment occurred after the sale, and therefore it devalued the site. But there weren't any adjustments of any kind to comp number 2. So it was only done to comp number 3, but it should have been done to comps 1, 2, and 3 because they were all at least 1.5 years prior to the text amendment. In any case, they didn't change the site value, and I was actually looking for the site value to actually be decreased. Now, as for construction costs, we directed them to use Marshall and Swift, and they used the November 2021 Marshall and Swift report. However, the construction cost did not go down from the first report, which led me to believe that perhaps they were just picking categories in order to justify their previous their previous construction cost factors for the as of right and the proposed. So I looked at the as of right based construction costs, and I found that they're using Class A office building fireproof structural steel frame with reinforced concrete masonry floors. However, I'm not sure that that's what this is in the as of right, because the plans don't say that. The plans actually say, where I could see was non-fire rated exterior walls. And so my question is more to the architect, in that I want to know what the composition of the as of right office building is, and is it in line with the Marshall and Swift cost factor that they used and the category they used? Because they also add in sprinklers, but the plans don't say that the building is sprinklered. So all that to say, they end up with $369 a gross square foot for the floor area, including the cellar, which is actually $63 more per square foot than it was in the previous report. However, you are correct that the soft costs did go down in this case, but being that the hard costs went up, it's a wash. And it's a similar thing in the proposed construction costs. They used Class A luxury residential building average, and that has a high cost factor, a high base hard cost. It's one of the highest ones out of the listing of luxury buildings. But luxury buildings connotes that you already have upgraded fixtures and finishes. So then my question is, why are they adding in extra money on top of their cost factor for upgraded fixtures and finishes? So I feel that they're just driving the construction costs up in order to meet their previous assumptions about what the base construction costs would be.
Okay.
And I feel that I feel they need to either use the luxury apartment category and get rid of the furniture and the fixtures and finishes, or go to a lower category. And then if they want to justify adding the fixtures and finishes, they could, but they really should not do both. So I'm happy with the overall decrease of the building envelope and building size, but I feel that they still have not provided a responsive financial analysis that fully addresses all of my questions.
Thank you. Okay. So definitely that doesn't answer to the minimal either. Okay.
Correct.
All right. Thank you. Commissioner Shetter.
Thank you, Vice Chair. I do have a problem with the minimum variance finding, and I have this for two reasons. Number one, number one based on numbers. Like if you look at the numbers in the financials, and I'll come to this in a minute, but like general idea, I look at this lot as it's getting the best of the two zonings, the best of the manufacturer and the best of the residential. From the manufacturer, they are getting that bulk that they would qualify for if they built an office building or a warehouse or whatever. But if you look at the other side, the residential, they are getting the use and they are avoiding building a less bulky building, meaning I'm talking about the sliver idea. And I'm not saying that the sliver should be exactly applicable to it, but some sort of like, I see some favoring from the idea of picking the best in the residential and the best in the applicable zone. This is just a feeling. But if you look at the numbers in the construction cost, and I did look at them, I see two main things that concern me. Number one, the cost figures. I want you to open the financials, please, and I'm gonna walk you through 2 pages. Page 48, I'm gonna start with it.
Just give me 1 minute.
Sure, take your time. I'm gonna put on my screen as well.
Okay, all right, I have it up. Yep.
This is page, I'm sorry, 54. give me 1 second. Yeah, 54, this is the commercial building, the 15-story commercial building. You see this number 209? This is the base cost they started with for the commercial building. They are talking about average class A building. If you scroll, and they are, by the way, the reference here, the section referenced and the page number referenced, I'm not sure if they are correct, but if you scroll down to page, yeah, and here this is average class A luxury residential. So these are the breakdowns for the cost calculations. If I look at the table here, this is the commercial office, this is class A, and this is average. This is exactly what they are using there. This is what they are talking about there in the breakdown in page. Again, let me go to 54. 54, average class A, they are using 209. Now let's go back to the table and look at the cost that should be used. Class A average, it's 148. So I'm not sure if they are doing the right thing here. And second, I'm gonna go back to page 54. This factor here, the inflation factor, it's 1.15. And if you look at the luxury residential, it's 1.35. Yesterday, I did look at one of the residential buildings. It was a variance from the same construction cost estimator and financial analyst, and this factor was 1.26. I'm not an expert when it comes to financials. I'll defer to Commissioner Brown on this, but does the inflation factor change within the city from Brooklyn to Manhattan? I'm not sure. Maybe that's correct. But these are like the two numbers that are alerting to me when it comes to the financials. In addition, like I said, I feel like the minimum variance finding is not made yet. Thank you.
Thank you. Okay, Commissioner Shibeta.
Thank you, Vice Chair. I was happy to see the reduction. I think it's much more in line with the community character. I hope that the applicant can respond to the questions that were posted by my colleagues in writing, so that we can, because I don't think this is something that can be done verbally in a hearing.
I agree.
So I hope that we can have another submission where these questions are responded to, so that we can move this case along.
Commissioner Yoon.
Thank you. I have no comments to add.
So I just want to go back to Commissioner Otley-Brown regarding the question that Commissioner Shetta raised. Does the inflation factor change from borough to borough or city to city?
I believe it must change from city to city. I'm not sure about borough to borough, but I think they're working off of a table with that. I don't think they're fabricating. I think they're going to the table and just plucking out what the borough percentage is for that particular year. But they should answer that question.
Okay, thank you.
But Chair?
Yes?
Yeah, my inquiry wasn't about from a city to city. Yes, from, of course, the inflation in Chicago, maybe it's too different from the inflation in Mexico City. I totally understand that. But I'm talking about within New York City. Would it change from Brooklyn? And that's what I exactly said. From Brooklyn to, let's say, Manhattan. That's what I'm struggling with. And maybe it does. I'm not saying it doesn't, but I just need clarification on this. One more thing, I didn't see a table, maybe Commissioner Brown, because she's more experienced in looking at this stuff. Maybe she saw a table for the inflation factor, but I haven't seen it submitted. If it was submitted, I would like them to refer me to that.
I think they should answer your question, absolutely.
Thank you.
Thank you. All right, next item, please.
Item number 30, 2021-64BZ, 205-207 Graves End Neck Road, Brooklyn.
All right. The application was last heard on June 7th. It was the initial hearing, and the applicant has provided its response to the comments that were raised at the last hearing. So the applicant has revised the plan. Board had directed the applicant to redesign the front of the building to be more aligned with the existing building abutting it. The applicant has also increased the attic area in the front. This results in an increase in the floor area to 1.24. Applicant is stating that it is using the predominantly built up FAR and which permits 1.35 in an R4 district versus a 0.75 FAR in a non-predominantly built up. I looked through the files and I did not see a predominantly built up analysis. We had asked the applicant, and typically in the past for any such projects where the applicant claims that it's a predominantly built up, we asked the applicant to provide a predominantly built up analysis on the drawings. All I saw was a note, but not a drawing or an analysis. So that needs to be provided. Also, I went through my notes and I don't recall seeing an FAR analysis map. And the reason I'm asking for it is because if predominantly built up is being, even though FAR is not being waived, but that is because it's being considered a predominantly built up. So, so they have to meet the predominantly built up to use the FAR, and that would actually not require therefore an FAR analysis, maybe. But I didn't see either. So that's where my issue is with this. So at the last hearing, this is a very odd shaped site. This is a through lot with frontage on Graves End Neck Road and Avenue V. The building fronts on Graves End Neck Road. And it's a through lot site and which has a depth of 110 feet and maybe more. So the applicant had stated at the last hearing that a ZRD1 was submitted to DOB regarding the interpretation of it being regarding the waiver of the rear yard equivalent, because it's less than 110 foot deep through lot. And applicant submitted the ZRD1 that was denied by DOB, stating that the lot is actually more than 110 foot. It's a zoning lot that has a depth of 115 foot. Therefore, it is not a narrow, is not less than 110 feet, and then would have to provide a required rear yard equivalent, which in this case can be modified to 40 feet from a 60 foot. And that basically made the applicant revise the through lot and modify the reapportion the through lot to make it into a interior lot by basically reapportioning 10 foot of the portion of the lot fronting Avenue V as a separate zoning lot, and that was I guess that is going to be used by the abutting owner or owned by the abutting owner. This is very unique, as I said, that we typically don't see through lot sites, and one of the findings of 73-622 is that the enlarged building will not alter the essential character of the neighborhood or the district in which the building is located. So we are looking at what is being proposed on the subject zoning lot. While the subject zoning lot has been reapportioned from a through lot to narrow lot to an interior lot, that is not before us. But I also want to be very clear that this is not something we are encouraging the applicants whoever is listening to do in order for them, in order for the applicant to consider 73-622. Nothing the applicant is proposing for this subject site is changing the experience of the block front along Avenue V. And this is a unique block. It's an irregularly shaped block with combination of several through lots and several interior lots and corner lot and one corner lot. So what the applicant is proposing will not necessarily change the character of the block front along Avenue V, which is a mix of buildings not facing Avenue V. All the through lots are fronting on Gravesend Neck Road with the rear yard along Avenue V, and the ones that are interior lot, there are I think 3 or 4 of them. So I think the character of the neighborhood is not going to change with this modification and what the applicant is proposing. But keep in mind, the reapportionment is not before us. It's just what the applicant is proposing. But I just want to put a note there. We're not encouraging such apportionment, but if that's not what it should be used for 73-622. So I really have no additional comments on the proposed enlargement, but I do want the applicant to provide the analysis of the predominantly built up and making sure it meets the predominantly built up to apply the maximum FAR that it allows, because the applicant is proposing 1.24 FAR, whereas the built if it is not predominantly built up, 0.75 would be permitted. In that case, we would have to look at the FAR analysis of the neighborhood to see how much of an ask 1.24 is in terms of the context. Those are my comments for now. Commissioner Otley Brown.
I had originally had a question about the justification for the 20-foot rear yard in the original hearing, but they provided a rear yard study that showed rear yards that range from 0 feet to 27 feet, and the proposal being 18 feet on the part of the property owner fell within the range. That, coupled with the 10 feet that you get from the easement, means that it's equal to as of right 30 feet. And so I'm fine with it. I don't have any other questions.
Thank you. Commissioner Shetta.
Thank you, Vice Chair. I want to second the comments mentioned by you. And the only thing I would like add is to thank the applicant for revising the ZRD one and resubmitting. Now the ZRD correctly reference the surrounding streets, Avenue V and Gravesend Neck Road. So I have no further comments to add for the current time. Thank you.
Okay, thank you. Commissioner Shibata.
So I'm going to limit my comments to the academic portion of this, which is whether, for me, is that this reapportionment is the only reason that this permit is something that would be available. I don't believe that any type of reapportionment to circumvent zoning is in the spirit of the zoning resolution. And that's all I want to say with regard to this case.
Yeah, I was going through the 73-622, and in that it says it may permit enlargement of an existing single or two-family detached or semi-detached residences, except cottage envelope buildings as such term is defined in section 6411 definition, utilizing the provision of 64-33 special bulk regulation for cottage envelope building within the following areas. And then it says an enlargement within the side yard shall be limited to an enlargement within non. So it doesn't refer to whether this can be applied to a through lot or not a through lot. So I'm trying to, I think the only question is if this were a through lot with 115 foot, then they would have to have provided 40-foot rear yard. That's what you're referring to, as opposed to now that it's interior, they're providing a 20-foot rear yard on their subject lot. Okay, that's how I understand it. Okay, I just want to make sure. Okay. And I think to that, when I was initially reviewing it, and with regards to the rear yard, and I was looking through my comments, I did not have any issues with the rear yard at that time, partly because of the same argument that Commissioner Otley Brown stated, is that easement is 10 foot deep, and likelihood of anything getting built there is impossible. But don't want to assume that. But and since DOB has required as a condition of the ZRD1 and CCD1 that lot 5 be used for driveway and off-street parking, that easement agreement would ensure that nothing can be built there other than maybe an enclosed garage structure. So you're right. Academically, you're absolutely right. I agree with you. That should not be, but in terms of the neighborhood context of this environment, we would end up still having a 30-foot rear yard. Maybe not a 40-foot, but a 30-foot rear yard, which is more typical of what we see in an interior lot. That's the zoning requires 30-foot. But you're right. I take your comments, and we should not be looking at this in that form. Okay, Commissioner Yoon.
Thank you. I don't have any comments to add.
Okay. Right.
Continued hearing items. Item number 31, 2021-67BZ, 2307 Ocean Parkway, Brooklyn.
All right. The application was last heard on June 7th, and the applicant has submitted its response to the comments that were raised at the last hearing. A ZRD1 was submitted to DOB, and DOB granted a conditional approval that the applicability of ZR 54-313 for zoning lots with non-complying front yard to allow vertical extension of existing building walls facing such non-compliance. And this is a question I had raised as to whether the applicant can extend into the front yard. And based on the evidence provided, DOB considered that the existing front yard and side yard to be lawfully non-complying, and thus ZR 54-313A and B applies, with conditions that the vertical extension complies with height and setback. Non-complying front yard where the building is vertically extended is minimum 10 feet deep, and non-complying side yard is minimum 3 foot deep and that the minimum distance between such building walls and the nearest building wall is 8 foot, and that the enlargement does not contain more than 2 dwelling units. So this, I'm reading this out because this should be in our condition. We are just taking what was stated in the DOB ZRD1, and it should be part of our conditions. And it should be in our resolution. The applicant has revised the proposed plan where the cellar height was corrected. And we had asked, since this is a semi-detached building, we had asked the applicant to provide the shadow of the adjacent structure and identify the existing legal non-complying yards. And the dimensions, they were mismatched with the dimensions. Those have been corrected. So, and the rear yard and FAR studies were also provided. So pretty much everything that has been submitted, I'm satisfied with the submission. Commissioner Otley Brown.
I am also satisfied with the submission. They had given us the FAR study and the rear yard study justifying their proposal. So I have no questions.
Yeah, thank you. Commissioner Shetta.
Thank you, Vice Chair. I am satisfied with the application as is right now, and I have no further comments to add.
Thank you. Commissioner Shibeta.
Thank you, Vice Chair. I'm satisfied with this application.
Thank you. Commissioner Yoon.
Thank you. I have no comments to add.
Okay. Thank you. All right. We're doing good with. right?
Item
So-
number, I'm sorry.
No, go ahead. I thought you wanted to ask me some question.
No. Item number 32, 2022 10BZ, 55 Prospect Street, Brooklyn.
All right. I think on this is we are waiting for a sign off, and we received some comments from DEP regarding air quality and noise. Ms. Benke?
Yes, that's correct. We are waiting. There was some confusion regarding, we received another letter from DEP asking for backup information, and we hope to resolve this issue soon. I don't know if it will be done today or not, but we hope so soon.
And that's the only sign off we require. We have the DOT sign off.
Let me just check my notes for a moment.
Yes.
Close. Yes, okay, thanks, John.
Yes.
So we have DOT sign off, and were there any hazmat? Do we have a sign off on hazmat?
Yes, we do. We can pull that up one moment.
Yeah, I have it in my note, but I wasn't sure if I just wanted to be 100% sure.
Okay. The hazmat sign off came on July 14th.
Okay. Are there any conditions from that needs to be incorporated into the plan?
We can check for,
Okay.
yes, we're gonna need the DEP notes for all of the sign offs, so we'll look at that. And there's also some conditions for the resolution from DOT that we have provided to the applicant and can provide to the board as well.
Okay, all right. So I don't think we are going to get anything from DEP. Do you think we'll get anything from DEP today?
I reached out this morning to see if a call could be connected, but I haven't heard back, so.
Okay, all right. Keep us posted. Thank you. Appreciate it.
Okay, thank you. Thanks. John.
So I have no comments. I guess we're waiting for all the sign-offs. Commissioners, do you have anything to state? Commissioner Otley-Brown?
Nothing, thank you.
Commissioner Sheta?
Nothing to add, thank you.
Commissioner Shabeta?
Nothing further. Thank you.
And Commissioner Yoon?
No, thank you.
Okay, thank you. All right. Sorry.
New cases?
Yes.
New cases, item number 33, 2021 55 BZ, 134 16 35th Avenue, Queens.
Give me a second. I'm just pulling up the drawings.
This is still the review session, people, just a FYI.
So we have received proof of service for initial filing and hearing. Community board did not vote on this application. Though the applicant did meet on June 6th, community board raised questions about the subdivision of the lot and is awaiting response from the applicant.
I'm sorry, the applicant did respond.
Oh, the applicant did respond? Okay. Okay, I guess my note is old. So did the community board, so the applicant did respond to the community board, but the community board is not going to hold a hearing until September, right?
September, yes.
Okay, thank you. We have received several objections from the neighbors, and most of the complaints are regarding property damage, construction impact to the tenants, quality of life, noise, light and air. And that the infrastructure is not keeping pace with the development. We expect public participation from the neighbors, and we will have an interpreter. So we will look towards Ms. Matias to guide us through how to conduct the hearing in that. The action before us is a special permit application pursuant to zoning resolution section 73-66 for a proposed 12-story mixed-use development on the subject site that exceeds the height limit established in zoning resolution section 6121. This is basically, this is a site that is being built as of right in terms of the FAR. However, because it is within the flight path of LaGuardia Airport, the zoning resolution requires that it seeks a special permit application through the zoning resolution section 7666. Now, I just want to see, before I get into the drawings, before I get into my statement with regards to the findings, the drawings that were submitted, the submitted plan shows a 2-story commercial building along North. So it's a through lot site there, and the applicant is proposing a 6-story building along Northern Boulevard and a 12-story mixed-use building along 35th Avenue. The 6-story building on Northern Boulevard will be a commercial building. However, the submitted plan shows a 2-story commercial building along Northern Boulevard and not a 6-story. And so need to clarify why the statement of fact is referring to a 6-story building, which may be permitted as of right. So if the applicant clarify, I recognize a 6-story building is not what is driving the height analysis. It's a 12-story building, but just to make sure that we are reviewing the maximum build potential on the subject site, including what is being proposed along Northern Boulevard. So as I mentioned, and I'm going to read out findings related to section 73-66 is really for the benefit of the listeners and the public participation as to what the findings of 73-66 requires. 73-66 basically states that the Board of Standards and Appeals may permit the construction, enlargement, or reconstruction of a building or other structure in excess of the height limit established under section 31-21, provided that the applicant submits a site plan with elevations showing the proposed building or other structure in relation to such maximum height limit, and that the board finds that such proposed building or other structure enlargement or reconstruction would not constitute a hazard either under the existing layout of the airport or under any planned reconstruction or lengthening of the airport runway, to the safety of the occupant of such proposed building, to other buildings in the vicinity, or to the safety of air passenger, and would not disrupt the established airway. So the board shall refer the application to the Federal Aviation Administration for report as to whether such construction will constitute a danger to the safety of air passenger or disrupt established airway. So board did receive an approval from FAA, which is Federal Aviation Administration, and Port Authority of New York and New Jersey. And all the conditions of FAA and Port Authority of New York and New Jersey would be reflected in the resolution. And we look towards FAA in granting this specific special permit, as FAA is uniquely qualified to make the determination regarding potential hazard to the airport, airways, air passenger, and the buildings in the vicinity. And for that, as I mentioned, we have received the FAA approval. So FAA approved 11 points on the zoning lot, mapping out the maximum building envelope within the building bulk. Its bulkhead and the obstruction light, and therefore must be located within that FAA approved height location, which ranges from 213 NAVD, 213 foot NAVD 88 to 222 foot NAVD 88. In all cases, the maximum height that is proposed, including the highest bulkhead, stairs, and elevators, would be at 194.41 foot NAVD 88, and the obstruction light mounted on top of the bulkhead would reach 195.91 foot NAVD 88. And both of these obstructions would be below the FAA approved height limit. So I think, as I mentioned, we look towards FAA to guide us on this, and if and all the conditions of FAA is what would be applied in this. I just again want a clarification. The action before us is to approve the FAA envelope that covers both the tax lot, one with the 6-story building that is proposed, and one with the 12-story building along 35th Avenue. The applicant should clarify that. And more for informational purposes, I ask the following question: if the proposed development along Northern Boulevard is within the permitted height limit, and why did FAA, if it is, then why did FAA review the points for the building along Northern Boulevard? I just, more for my informational purposes, I asked that question. There is a partial stop work order on lot 55 and lot 120. There has been, these are active violations dating from 2000 and related to construction, and recent one related to benchmarking on lot 55. So I don't think that's much of an issue. However, there are 3 ECB violations for lot 120 related to construction safety. And I think what I would say is that any construction that is going to happen on this site has to be, will be monitored by DOB, and DOB will ensure that the developer of the site is abiding by all the city regulations regarding construction, and will monitor it accordingly. So, Commissioner Otley-Brown?
I just have a question. I haven't been able to find the FAA letter.
I did.
No, it's, I put it in, it's last
I
week.
did receive it. I did receive it. I think it was a request. Yeah, we got an email.
Yeah, but I uploaded it into,
I see.
I uploaded it into SharePoint, and if you see, it goes, there's a letter, and then it says the AEO numbers from one point to another point. Let me see if I could find it.
All of the AEA DNHs. That's it?
Right, there's a August something letter there.
Okay.
Yeah.
Okay, thank you.
All right. Given that the FAA and the Port Authority have signed off on this case, I have no questions.
Okay, thank you. Commissioner Sheta?
Thank you, Vice Chair. I go back to the point that Commissioner Brown raised. Actually, I haven't seen the FAA approval. Tony, if you're talking about the letter that we got on August 4th, the letter or the cover letter did say that attached are 2 letters, one from FAA and the other one is from Port Authority of New York and New Jersey. What actually came to the board is just 1 letter, not 2. And this letter is coming from Port Authority of New York and New Jersey, nothing from the FAA. Second, if we're looking at the forms that were submitted to FAA with the site elevations and the coordinates and the building heights for the 12 points, I don't think these should be considered as an approval from FAA. These are just passes for the 12 points, indicating that these 12 point elevations, top of building elevations, are okay for the FAA. But I do believe if we don't have the letter, we need to get one.
All right.
I'm listening. Yeah,
They
go ahead.
said no impact, but a pass or no impact, but if you want the applicant to explain that, and then you want a letter, then we'll get it from the applicant.
I will explain why I'm saying that.
Okay.
If you look at the and let me just put my notes on the screen, not sharing, but just try to start reading them. Bear with me 1 sec. Yeah, so at first, like I said, the FAA approval, I didn't see it. The second comment is I would like to know the status of construction, whether they started excavation or not. The next comment, submit more legible copy of the survey, as the one submitted is not readable. It's not legible.
Okay.
My understanding is that the site elevations for points 1 through 11 are submitted or were submitted to FAA in NAVD 88. Please confirm. And then I will come to the aeronautical study. And before I start with my comments, I want to praise this study. Probably this is one of the best reports I ever read in my life. I love it. It's very well structured. It's very clear. And it does say on page 5, and that's what concerns me. The building has not yet been filed with FAA. This is page 5 of the PDF. If you want to take a look at it,
Okay.
You can open the file and let me know if you see that.
Unfortunately, I can't. do
Why
it.
am I having difficulty finding the report?
So my understanding is probably the study was prepared before the submission to the FAA is done, and maybe the submission was done later on. But if the submission is the 11 points, I'm fine with that. We just need a formal letter from the FAA saying that yes, the filing is okay. Go ahead.
Yeah,
The next
Commissioner Shetta, you're right. I think the report was written on June 4th, 2021, and the
Yes.
FAA review is from June 30th of June 30th of 2021.
And Chair, Vice Chair, by saying the FAA review, you're talking about the 12 forms for the 12 points, right?
Yes,
You're
yes.
referring
I'm
to
looking
that.
at the detail for case point 1.2, notice of proposed construction or alteration of airport.
Yes, my understanding is that these forms are submitted online, and there is kind of like an online application or a software for the FAA where you can go and put the project data and put the site elevation for a point and put the coordinates for that point so the software knows the location, and then put the building height, and automatically when you run that application or FAA software, it checks against multiple surfaces in the area. And if that point doesn't like constitute an issue for the aerospace activity, they say it is okay, it passes. But I'm not sure if they could be considered as a formal approval from FAA. We need to get some clarification. Maybe if Mr. Pittman is present, he's the best to educate us about that.
Okay.
In the study, if you look at page, I don't know what page is this, maybe page 6, 5 and 6, the elevation for runway 31, when checking the possible building height, once they used elevation 6.7, and the other time immediately on the next page they used elevation 5, and they were checking against the 150 and the 134 surface. So I'm not sure if we're looking at the same reference point. I'm not sure why would that elevation, maybe it's a typo, but again, I'm waiting for a clarification on the drawings. And I'm going to start with the point you raised, Vice Chair. I'm not sure if you looked at the latest version of the drawings, but the drawings I'm looking at.
These were drawings that were submitted on August 8, 24, 2021.
Yes.
Okay.
This is the building along Northern Boulevard, right?
Yes.
And when I scroll down to the elevation, I see that, sorry, I believe this is 6-story building, it's not 2, right?
Yes.
So I'm not following your comment about that.
Okay, you know what? I was looking at the old drawings.
Okay.
Sorry,
Thank you.
Thank you for that.
That's okay. I just wanted to like put the right thing on the record. When it comes to the drawings, I don't know why I took him off the, sorry. Let me put him back. I'm gonna need him. But when it comes to the drawings, if you look at, one second. Yeah, if you look at these, why it's not zooming?
You're looking
Yeah,
at
you see,
BSA
this is
03,
page.
BSA
Yeah, this is.
03.
I'm sorry, go ahead.
You're looking at sheet number BSA
04.
03B.00.
Yes. This is BSA-04 and probably 05 as well. I'm talking about this table here. I do have two issues with this table. Number one, what are the numbers listed in here? Are these actual? I don't think these are actual top of building elevations. First of all, that what it says here, that cell, the heading in that cell, I'm not sure why it's doing that. One second. Yeah, this naming here, approved height by FAA. Please change this to approved top of building elevations. Approved height is approved height. This is, if somebody reads this is going to be perceived as the height of the building. The numbers here are not height of the building. I totally understand that you put NAVD 88 here, meaning that these could be elevations, but it's more clear to say approved top of building elevations by FAA or some sort of language like that. So it's much more clear. If somebody who doesn't have experience in handling these kind of cases reads these numbers and take a look at just the first two words here, approved heights, he's gonna perceive these as heights of the building, which is untrue. So that needs to be fixed. This is point one. The second, like I said, if these are elevations, I looked at the 12 points on the drawings, like as they stand on the elevations. None of them has elevation 222. None. So I'm not sure why are these numbers here. Yes, they might be approved by FAA. Maybe FAA allowed you to go as high as that. But if you're limiting your building to 213, elevation 213 or elevation 214, please use these in the table. Put these numbers in the table, and like I said, call them top of building elevations, not approved heights. The other thing, if you look at the drawing here, this is one of the surfaces that's used by FAA to check the building against, and based on which the FAA says, yes, this building is good, or this point, I would say, is good, this point is not good. And what is shown here is the 150 slope, the 150 surface, the approach surface that has a slope of 150. What is actually being used on this case is not the 150, it's the 134. And that was indicated in the Aeronautical Study. They said the FAA doesn't protect against the 150, they just protect against the 134. This is page.
I think this would be best explained by Mr. Pittman.
Yes, that's correct. But if that from the drone perspective, if you want to show a surface here, I would rather show the surface that govern the elevations of the building. On one more point on the drones, and this is here. And again, I need Mr. Pittman help on that. In the study, it says that this surface here, that dash red line, starts at the end of the 150 foot above the air. So this schematic explanation is not accurate, because you see that surface, it doesn't start at the reference point. I believe that this service should start at this point here, where the cursor is. This is a big deal when it comes to like determining the allowed building height, because this is.
Can you
almost-
point to which drawing you're looking at? What is the sheet
Sure.
number?
This is BSA-01B.00, and this is the section diagram.
Okay.
And what I'm referring to is there is a service that's 150 feet above the airport. And then when you come outside the 10,000 diameter of that zone, there is another surface that's the conical one that slopes at 120 or 20 on 1. And that 20 on 1 service, the way it's shown in the drawings, it's shown to start at the airport reference point, but the aeronautical study doesn't say that. It says it should start at the end of the 150 horizontal surface. So meaning that it should start at this point. So this dashed line should move downward to that point and stay parallel to that. So I need them to correct that, because based on my reading for the study, I don't think this schematic detail is accurate. And that's what I have for now. Thank you.
I just want to go back to one comment you raised, is that why is that table showing all the elevations which are not applicable to this 12-story building? If you go to BSA drawing 03A,
Sure.
in that 03A, it's the site plan, right? In that, it actually references all the 11 points
Yes.
that FAA studied. So, and this is a more of an academic question that I have, is that even though the highest building on this zoning lot is on 35th Avenue, FAA studies the entire zoning lot and
Yes.
it seems is looking at the entire envelope and looking at the maximum points of the zoning lot to say what can be the maximum height at each one of these points. And should there be any modification within the envelope, it has to stay within those points, I think. So that is why the applicant has provided that chart, providing all the different elevations, which may not have any bearing with that special west elevation, because that west elevation, it's probably only the 213 foot that is applicable, which is highlighted, and not the rest of them, I think.
But Vice Chair?
Hmm?
I believe I didn't explain it well. And that's why maybe you didn't get what I meant. These are 11 or 12 points, whatever, right? For each point, they submitted a form to the FAA. With that form, you have 3 pieces of information: the coordinates, the site elevation, and the height of the building. If you look at the drawings, FAA permitted them to go to a specific height, and they elected to limit the building. You see this line here?
Okay.
The top, this is
Yeah.
almost elevation 213. This is the maximum, I'm sorry, the red line. You see
Yeah.
that? This is the maximum height that the building could go to according to these drawings, elevation 213. There is no single point on these drawings that has an elevation in excess of 213. Do you agree?
Okay.
If you look at that table, it's showing the 12 points or the 11 points, and it's mentioning that the elevations of some of them as high as 222,
Right.
260, 240.
Yeah,
That's for me. That maybe I can understand it, but if
think it
an
means.
examiner,
I'm sorry, I thought it meant that was the height that FAA would be okay with according to determination that was presented.
Right. On this, if you look at this site plan, if this building was located on point number 5, which is at the corner of Northern Boulevard, then the maximum height one could have at that corner was 222. That was the height limit of FAA. So I understand what you're saying, but I think the relevance of this is based on the entire, so maybe it's a more of semantics. It's not an error in terms of the information that has been provided. The
No,
applicant
I'm not saying it's an error. No, I'm not saying it's an error. I'm saying it's just confusing. That's what I'm saying.
Okay. All right.
But what is more confusing, like I said, is the terminology here. Approved height by FAA should be approved top of building elevations. So it's more clear to understand.
Yeah, or it's like something like maximum height approved, would be approved by,
Right.
or, yeah.
No, height is not elevation. Height is
Right,
level.
elevation, sorry,
Yes,
you're right, yeah.
exactly.
Maximum
Thank you.
elevation. Yeah. Okay, thank you. Commissioner Shibata.
Thank you, Vice Chair. I want to thank you for your detailed explanation as to exactly what we're here to review and what we're limited by in our review. And I do appreciate the notes of Commissioner Shetta, and I seek to see what the explanation is with regard to whether or not there is a final determination from the FAA as to this height. And no further questions from me.
Okay, thank you. Commissioner Yoon.
Thank you. I have no comments to add.
Okay, thank you. All right. Are we all doing well? Should we continue?
Yeah.
All right,
May I go on?
please.
Item number 34, 2021-61 BZ, 4080 Ocean Avenue, Brooklyn.
So we have received a proof of service for initial filing and hearing. Also, the community board approval has been provided. Community board approved unanimous, well, 34-1. So this is an application for a special permit pursuant to zoning resolution section 73-622 to enlarge an existing residential home and is seeking a waiver of floor area, FAR, open space, lot coverage, and rear yard. The width and the lot of the subject zoning lot is legally non-complying. So the existing side yard and the rear depth is also legally non-compliant. So my question is the lot width being proposed to be? The reason I'm asking this question because it's confusing. I think it was a mistake, but the application should clarify that. Is the lot width being proposed to be increased to 40 foot width from existing 30 foot? Because somewhere in the report, it refers to 40 foot width as indicated in the zoning chart, because if so, it is consistent with the proposed plan. The statement of fact, the zoning analysis chart states that there are two side yards. According to the survey, there is only one side yard, which is 4 foot 9 inch wide along the south lot line. And also per the side yard study, the subject site has only one side yard. Now, there is about 2 foot 6 inch of wide open space along the northern lot line, but it is not a continuous side yard from front yard to rear yard. It is more like a courtyard. So I'm not sure if the applicant is referring to that as an existing side yard. And we have to be careful because the existing condition, as I see it, shows one side yard, which is non-complying, and a 0 side yard on the other side. What the applicant is proposing is different. It is actually improving the non-compliance. I'll get to that. So indicate in both the existing and the proposed plan, the existing projection in the side yard along the north lot line, because I have to say this, reviewing this plan was very difficult. It is not done in the language that is used for these cases were not thoroughly carried over by the architect on this case. So maybe we can give a sample plan for the applicant to follow. And that's why I think a lot of my questions are coming up with regards to the existing and what is being proposed. Indicate in both the existing and proposed plan, the existing projection in the side yard along the north lot line. It seems these are skylights over the cellar. And my question is, are skylights over the cellar permitted in flood zone? The site is in a flood zone. And as I said, as a general comment, I think the site plan and the floor plan, they lack dimensions. All the dimensions throughout the plan should be provided and should be consistent. It should be either 21.6 foot or 21.6 inches. But it's in the same plan. We are seeing feet in decimals or feet and inches. So please be consistent throughout the entire set of documents. And also carry the dimensions of the lot width, the front yard, rear yard, side yard setbacks, not just for the site plan, but also from floor plan to floor plan, from first floor, second floor to attic. So this is an existing one-story building. It's an interior lot, and the applicant is proposing to enlarge to add a second floor and an attic floor. And the proposed enlargement will result in a 0.93 FAR. The permitted FAR in this is 0.5. Sorry. The applicant in its proposed plan should indicate the proposed parapet wall height on the elevation and section. Based on the plan, it seems that an additional side yard would be provided along the on the northern lot line, and what the applicant is proposing is basically pulling the first floor from the northern lot line away. And this is allowing for a side yard. And then the applicant need to make sure those existing skylights that are above the cellar, A, they're permitted, and B, they're permitted obstructions in the side yard. This would, of course, by pushing the building away from the northern lot line, would make the building more compliant with regards to the side yard requirement, which is good. The proposed floor area diagram has dimensions, like I said, in feet and also in inches and also in decimals, so needs to be kept consistent. Per floor area diagram, 109 square foot on first floor and 97 square foot on second floor and 127 square foot on attic floors are being proposed to be deducted from the floor area. I could not locate it on the floor plan, so if the applicant could clarify that. In the proposed plan, as I mentioned, applicant should indicate the side yard, the front yard, the rear yard dimensions for all floors, indicate the depth of the existing and the proposed terraces and balconies. The reason I ask for that is regarding the balconies, on the balcony that is proposed on the second floor along the front yard. It is over 15 feet, the front yard is 15 foot deep, and the applicant is to ensure that this proposed balcony on the second floor complies with zoning resolution section 23-131, which basically, based on the text, it says that the proposed balcony can exceed 50% of the width of the plane surface of the building wall from which it is projecting, and also maximum 6 foot into the front yard is permitted to be projected. I think it is more than that. The applicant needs to meet the zoning resolution section 23-131. In terms of the basic threshold retention of the existing exterior wall, the applicant is stating that 65% is being retained. In the wall calculations sheet, the northern wall on the first floor is being removed and relocated. And it was not also accounted in the wall to be removed calculation for first floor. And if that were to be calculated, the reduction, this would reduce the percentage of the existing wall to be retained to less than 50%. And so as I mentioned, our basic threshold that 50% of the existing exterior wall needed to be retained. And I think that can be achieved by retaining some portion of the 13-foot 6-inch wall along the south lot line in the front, and that can achieve the 50% on the first floor. And this would not affect the second floor. The second floor plate can hang over along the south side, and you could still maintain the floor plate of the second floor. And I would like the applicant to add a note to the plan that BSA is not waiving the permitted obstruction, including balcony and any of the regulations stated in Appendix G with regards to flood regulations. DOB shall review for compliance. With regards to the findings under Section 73-622, the applicant has provided a rear yard study. The site has a pre-existing non-complying rear yard depth, and the proposed enlargement would retain it. Though it is not clear from the plan, the depth of the rear yard above the first floor. So that's why I asked for the dimensions of, yes, Carlo?
Yes, Madam Vice Chair, just to clarify, are there elements on the plans that aren't before us that should perhaps be removed?
Well, because it's in a flood zone and there is the cellar, which is going to become, the applicant is proposing it to be just a shell with no living or any activities to be occurring. I just want to make sure any of the specific terms and languages that has been used with regards to compliance with flood regulation, we are not opining on that. And also that the existing cellar extends into the north, on the north lot line, and it has a skylight. And I don't know if that is permitted, and if it's an existing, is it if it is allowed, or if there would be any change in the design requirements or other things. So that's why I don't want us to opine on that. I want that to be completely under DOB's purview.
Very good, thank you.
I don't know if that gets counted as a permitted obstruction, therefore, as part of the Appendix G also.
Okay.
So may I continue? Does that answer your question?
Yes, thank you.
Okay. So with regards to the rear yard, as I said, it's not clear from the plan the depth of the rear yard that is being proposed above the first floor. Also, the block front lacks a very, and as the rear yard study shows, the block front donut, that is, lacks a uniform rear yard depth. In terms of the FAR, within the study area, there are 16 homes that have FAR over 0.6 FAR, of which 2 homes are already above 0.9 FAR. So the proposed FAR of 0.92, I was okay with it. And this is a narrow site. Some of the other sites are much larger. So in terms of the total floor area on a larger site with a 0.6 FAR probably would be same as the floor area that the proposed enlargement will be providing. What the analysis did not show was the front yard. This particular block front has a very uniform front yard, and where the building first floor, the second floor sets back from the first floor. And in this case, the applicant is proposing to extend into the front yard, and the block front, as I mentioned, has a very uniform front yard. So at a minimum, the applicant should retain the built context and set the second floor back from the front yard, from the first floor. And this way, if they shift the second floor back, they can recoup it in the rear by about 5 foot or so. I would be okay with having that bulk being moved into the rear yard, especially as I mentioned, this particular block does not have a very uniform rear yard. And also the balcony that is overhanging the second floor encroaches into the front yard, which further actually changes the front yard characteristics of this block front. So that that needs to be revised. Those are my comments. Commissioner Otley-Brown.
So I too found that 4 foot 7 inch front yard a little confusing because it didn't appear as if it was 4 foot 7. And then I went back to the existing plans and I see that the first floor seems to have taken the same footprint as the new cellar floor that's raised. And so I'm thinking it must be a pre-existing condition then that they want to keep, which I suppose would be fine, except they should just label the side yard what it actually is, and then talk about how they are retaining the pre-existing non-complying envelope of the building that's almost against that side lot line, except for the little court area.
Mm-hmm. Yes.
So that would clarify it for me. That was my major question with this.
Okay. Okay. All right. And you're okay with the rest of the proposal?
Yeah, because I think the FAR study shows that there are at least a couple of homes that are a larger FAR than this one on the block. So I was okay with that. And I was fine with the rear yard on the cellar / first floor being 20.83 and then cutting back to 30 feet on the second floor and even more on the third floor. So I was fine.
So what I'm proposing is that in this case, the front yard is being encroached upon with the building. I'm recommending that the front yard may be widened on the second floor. And if that requires the second floor plate being pushed back into the rear yard by 5 foot or so, it would reduce the depth to 25. And that
I'm fine. I'm fine with the 25 in the rear on the second floor also, because we've seen that in other cases and it's still going to have like kind of a nice cutback look in the rear. I'm fine with that.
Okay, thank you. Commissioner Shetta.
Thank you, Vice Chair. I'm fine with the comments you raised on the rear and the front yards. Other than that, there were like some typos in the statement of facts on page 4. For example, it says the proposal will create a 20.8 rear yard. I believe according to the drawings on the second floor, it says the proposal will create a 20.8 foot rear yard on the second floor. I do believe according to the drawings that the rear yard on the second floor is more than that. The zoning analysis form, it indicates that the residential floor area is 2,987 square foot, and then the total floor area is 2,786. I'm not sure if there was like a deduction. Is this a typo? So if it's a typo, just need to be fixed. If this is because of a specific deduction, then that's fine then. And I do agree that they should add a note to the plan regarding the compliance with Appendix G. I would even add to that on PSA 009 and 0010, when they are pointing to the flood vents, it says 16 inches by 8 inches flood vent in cellar below FRCE. I would add like between parentheses to be designed and reviewed by others. So it's not before us, because my point is, if when they put that dimensions of the vent, it gives the impression that we're blessing the dimension, and we're not looking at it at all.
Okay.
Thank you.
Thank you. Thank you. Commissioner Shibata.
Thank you, Vice Chair. I support your comments. I agree with them. I have nothing further to add on this application.
Okay. Thank you. Commissioner Yoon.
Thank you. I also have nothing further to add.
Thank you. All right. Are we down to the last one?
Nope. Item number 35, 2021-69BZ, 24010 Merrick Boulevard, Queens.
All right. We have proof of service for initial filing and hearing. Community Board recommends approval with condition And the conditions are, New York City DOT will install no parking signage next to the bus stop. Applicant will install a speed hump at the end of the drive-through before cars can exit onto Merrick Boulevard eastbound. New York City DOT will install no parking signage along the front of the property. Applicant will seriously reconsider allowing this restaurant to have indoor dining. So the action before us is, this is a subject site that the subject site is in a C13 commercial overlay where eating and drinking establishment, that is use group 6, is permitted as of right. The action before the board is a special permit pursuant to zoning resolution section 73-243 to permit an accessory drive-through facility for the as of right eating and drinking establishment proposed here. This is a high irregular lot. It's an L-shaped zoning lot consisting of 3 tax lots, and it is at present vacant. I believe there was an automotive service station that used to operate at this site pursuant to a BSA grant on this that was granted, and the service station was demolished in 2001. Since this was a gas station, the applicant has also has provided all the documents regarding the New York State DEC, all the closure reports regarding the tanks. I believe there are 2 UST that are closed in place and 1 UST that's been removed. This is a proposal, as I mentioned, for an as of right 1-story eating and drinking establishment. I believe it's a Starbucks. And the applicant is proposing a 12 accessory parking space. 6 is required, and all the access to the site would be from Merrick Boulevard, which is a 3-lane, it's a 2-way divided major thoroughfare with 3 lanes in each direction. And the access would be, though it's the corner lot, it also has a frontage from Brookville Boulevard. I believe in its earlier iteration, it did have an entrance from Brookville Boulevard, and based upon the reviews from DOT asked that curb cut access from Brookville Boulevard be eliminated and only access from Merrick Boulevard be permitted. So the applicant modified the site plan based on the comments it received from DOT. And the proposal is an entrance and exit from Merrick Boulevard. And this particular facility is going to be primarily a drive-through pickup. There would not be much seating. People won't come and sit and eat, but the zoning requires that 12 parking spaces be provided, and that is going to be used for people who order and for pickup. So our focus is on the drive-through. The findings are with regards to zoning resolution section 73-243, which is basically a grant of a maximum of 5 years. 1 is reservoir spaces. The applicant is proposing 17 reservoir spaces. The requirement is 10. In addition, the applicant is providing 12 accessory parking spaces on site. B, drive-through will cause minimal interference with traffic flow in the immediate vicinity. As I mentioned, Merrick Boulevard is a divided 2-way road. It is a commercial office corridor. Access to the site will be provided only from Merrick Boulevard via 1 curb cut that is 24 foot wide. And as I mentioned, per DOT's Jan 2022 comment letter for safety and operational concern, both off-site and on-site curbs from Brookville was removed. And this was to allow for an uninterrupted drive-through and queuing space. And since Merrick Boulevard has a raised median access, the access to the site will only be from the eastbound direction from the Merrick Boulevard. So anyway, only vehicles making right turn from Merrick Boulevard will be able to enter the site, and vehicles exiting from the site will only be able to make a right turn and exit and merge in with the eastbound traffic flow. So there won't be any left turn of any sort to go to the other side of Merrick Boulevard. So the proposed building, also the applicant is setting the building back from the property line. And as the applicant states, this would allow for an unobstructed sight line between the pedestrian and vehicles exiting the drive-through and the queuing area. So the in the statement, the applicant states 3 additional queuing spaces for vehicles would be provided in the parking area. I'm wondering, is that 3 addition to 17 reservoir spaces? It wasn't quite clear, and if the applicant can clarify that, where that would be located on the site. And I'm assuming that is for vehicles exiting the drive-through, but it was not clear, so applicant should clarify that. The applicant has also provided travel demand analysis. DOT is reviewing the travel demand analysis and has asked for additional information. I think I just saw something pop up where DOT has asked for some additional information and adjustments in terms of the depth of the car lane. I think DOT is asking that the applicant use a 22-foot deep car width for the drive-through and not a 20-foot or vice versa. Tracy, please correct me if I'm wrong.
Yes, 22 feet.
Right, so
They're
DOT has
recommending.
22 feet, okay, yeah?
Yes, for the queue, for the vehicle spacing.
Okay.
So that might affect the queuing somewhat.
Okay, thank you. So a traffic impact study was also provided in July, and according to the study, the proposed project will not have significant significant traffic impact, since most of the trips would be passed by. I'm assuming this analysis has been sent to DOT for review. Now, according to the analysis, the facility is expected to capture most of the trip from the existing traffic that is passing the site, which is eastbound traffic. The analysis breakdown shows, though, that almost 50% would be passed by and 50% would be new trips. So I'm not sure why the statement is saying it will be predominantly, it's 50-50. It's not 80-20 or 70-30. So I look towards DOT for its review. The community board had made some recommendations with regards to providing no stops, no parking sign, and providing a steep speed bump at the end of the drive-through. I would like the applicant to respond to those comments, and if those can be provided, and more importantly, would that be, is DOT aware of these conditions, and would that be okay with DOT? With regards to finding C, complying with accessory parking regulation, the accessory drive-through facility will fully comply. As I mentioned, 6 parking spaces are required. The applicant is proposing 12 accessory parking spaces, including a handicap parking space. With regards to finding D, that the character of the commercial zone street frontage within 500 feet of the subject premise reflects substantial orientation towards the motor vehicle. And as I mentioned, the block frontage of Merrick Boulevard is Merrick and Brookville have a commercial overlay of C13, which permits local retail use group 6 uses, including eating and drinking establishment as proposed on the subject site. So I think the proposed use would be in character with the commercially zoned street frontage. With regards to finding E, the drive-through facility shall not have an undue adverse impact on the residents. And F, that there will be adequate buffering between a drive-through facility and the adjacent residential uses. I'm going to have, my comments are similar for both of them, so I'm going to lump them. In terms of the site context, per proposed plan, the menu board will be facing Brookville Boulevard, away from the residential homes along 241st Street. These homes abut their rear yard about the subject site. Also, lot 94, that is abutting the subject site along Brookville Boulevard. It's a commercial use. It's built to the lot line. So I don't think the menu board's orientation facing Brookville Boulevard would affect this commercial use that at present is vacant, but would not affect the commercial operation on this lot 94. The applicant also provided noise analysis, and applicant states, and as you can see from the drawing, there is a 12-foot high concrete wall that is abutting the residential uses along the rear lot line. Now, according to the noise analysis, the noise level will be less than the maximum permitted, and that is factoring in the existing 12-foot high concrete wall, which provides acts as a noise buffer. I would like the applicant to provide some additional information about the existing 12-foot high wall. Who is responsible for maintaining it and why is it there? I'm assuming it is as part of the old gasoline service station, but applicant should clarify that and want to make sure that it is in sound condition. Is the 12-foot high concrete wall continuous? Based on the survey and the photos provided, it is abutting residential lots 116, 118, and 119. These lots have residential homes. However, lots 112 and 114 are vacant at present. And I think these lots were part of the gasoline service station, which has been now reapportioned to be part of the resident to be developed for residential purposes. So finding F is inaccurate because the concrete retaining wall is abutting 3 of the 5 residential lots. It should factor in the potential development on lots 112 and 114, and should provide appropriate noise retention along those rear lot lines. And as the plans show, the landscaping along the rear lot line is almost non-existent, and the driveway in some places abuts the concrete wall for most of its length. So since there is ample green area provided behind the building, okay. So my comment is, as I was looking at the proposed plan, the proposed building will have a lot of green area behind it. So my question to the applicant was, can the proposed building footprint be made narrower and longer to make space for a green buffer, especially along the lots 118 and 116? So this way, the driveway can be moved a little bit away from the rear lot line and allow for some greening. It is not, the reason I'm asking is while lot 112 and 114 are very far away from the menu board, it would be right next to the pickup window. And while there typically is not much of a conversation, vehicles do stop, and so there would be some noise associated with the sound of the engine and some interaction. So, so it is not, there needs to be a little bit more buffer provided along the lots, the rear lots of lot 112 and 114. And I would, it's not clear from the plan what is being proposed. Is it a chain link fence? Is it a vinyl fence? I think the perimeter treatment needs to be same as the other lots. And I think a 6-foot high vinyl fence, if that is being proposed, is not adequate, since the elevation of the street elevation of 241st Street is at a higher, it is at a higher elevation than the subject lot. So any building that would be built on lots 12, 112, and 114 would be more at grade with the 241st Street, and a 6-foot fence height would almost come to being like a 3-foot from the residential point of view. So it should be same as 12-foot high as existing with the concrete wall. And as I mentioned, I think a 6-foot high fence would not be adequate in terms of providing noise and visual buffer from the pickup window and the drive-through lane. So a vinyl wall is not adequate. At a minimum, I would suggest that the applicant continue the 12-foot high concrete wall along the remainder of the rear lot line. And the applicant should also post signs along the drive-through lane that the customers should lower their radio volume and no honking. The plan also has a detail of an aluminum fence. It wasn't quite clear where this aluminum fence be located. So the applicant can clarify that during the hearing. The pedestrian crosswalk that is within the site, this is the crosswalk that would take a pedestrian from the 12 parking spaces into the building. They should be painted yellow. With regards to the lumen spread, again, I want to be consistent with the cities. I want the lumen spread to be consistent with all the applicable city standard as it would apply to an as-of-right development. And I would like to know what is the proposed height of these posts. I believe the DOB standard is I could be wrong, and maybe Commissioner Yoon, you can weigh in on this. At a minimum, and we are actually looking into the standard of the lumen, so we don't have that information, but at a minimum, the applicant should add a note to the plan that all lighting sources that are located adjacent to the residential uses shall be shielded from direct view and to minimize effect and to minimize any adverse effect on the surrounding residences. So I spoke a lot, Commissioner Otley-Brown.
So I just have 2 questions about this. The first one is that the trash will be stored in an enclosure in the parking lot, and the trash enclosure backs up against the residential lot line. So my question is, could it be moved to the other side of the parking lot? And my other question is, I could not find the physical distance of the menu board speaker to the nearest home noted on the plans, and it would be helpful if they could just put it on the plans for reference. Those are my 2 questions. Otherwise, I found the application to be pretty thorough, and I agree that this area, it operates more like a suburban area where orientation to the motor vehicle use is common. And I find they're putting plenty of parking spaces on the site in addition to 17 reservoir spaces. So I really don't have any other comments. Just want to make sure that the positioning of the menu speaker is far enough away from the residences.
Okay. I just want to go back on the trash storage, and this probably will be consistent with the comments that I had raised with another project, which was an existing eating and drinking establishment with regards to the location of the trash. I think as of right use, the trash location is what.
Can I just state something before you even go any further? This hasn't been built yet. I could see if it was built. This has not been built yet. And for that reason, I'm asking a question. I'm not making a demand, just making a request.
Fair enough. Thank you. Okay. Commissioner Sheta.
Thank you, Vice Chair. I will start with the demand. Actually, the trash enclosure is not located next to a residential. My understanding is that the vacant lot right behind the subject property is a commercial lot. So if the trash enclosure is not located against one of the existing houses, it's against the
Commissioner Sheta, I think it is vacant. You're absolutely right. The 2 lots are vacant. It was, I believe, part of the former gasoline service station, and it was reapportioned. But the zoning district on those 2 lots do not permit commercial use. It can only be used for residential or
Oh, I
community.
see, I see. My bad. I
So that's
apologize.
why Commissioner Otley asked.
Then I second the demand by Commissioner Brown.
I think
this is-
Commissioner Brown said. it's
Not a demand, just a question.
Okay. Whatever.
Thank you.
Sorry about the confusion. Yeah, I agree with the comments you raised, Vice Chair. I do believe that they met all the findings. I do like the design of the facility, like the site plan. Just few things. Number one is the lighting. I do see that they submitted lighting diagram. I'm not sure if you saw it, Vice Chair, but this is drawing it's Z-007.00. If you're looking at the PDF, this is page 11, page 8 of 11.
It's very interesting. When I want to find the drawings, I cannot find it.
It happens.
Just give me a second. Let me pull up the drawings. And you're saying it is Z, which one? Yeah.
Z-0, go to
Z7.
page 8 of
Z7.
11.
Z7, got it.
Yep. Now let me just put that again. If you look at that luminous spread, I can see they did, number one, they did modeling because they cannot take readings. The system is not there yet. And I totally understand that we're changing some direction on that luminous spread. But if you look at the adjacent residential, even with the modeling, you're gonna see some readings in excess of 1, almost 2. You see 1.8 here, 1 here. Yes, the rest is within 0.5, which I'm okay with, but to caution them. And I don't want this applicant like go build something and then come back with complaints after construction. I do, and this is a suggestion. It's not a requirement. If you don't want to buy it, don't buy it. Go build whatever you want. But if we get complaints, you're gonna be back. I would suggest that the light poles here, here, and here be limited to 10 feet tall. That would like significantly mitigate the spread on the residential property. And I'm not trying to be stringent because the next comment will show that. On the landscaping next to the retaining wall, I would suggest to stay away from this retaining wall. I did walk the area and I can see elevation difference between the front of that site and the residential properties of probably 10 feet. I didn't measure them, but roughly. Let me just. What I'm talking about between here and this, and if you walk that way and come to that way, you look at these properties, there is significant elevation difference between these. That means that this wall is acting as a retaining wall, it's significant loading on it. If you want to put planting here, I am afraid that this planting and these plants will make the soil condition here like change, probably soften because of the irrigation activity for these plants, watering and then drying and then watering and drying. So I would leave this section here alone. Okay. Up to here, I'm fine with the landscaping, but from this point and going forward, even eliminate that. The fence treatment, I'm fine with whatever fence treatment the board would agree to. Then I'll talk about the noise. I see that the proposal call for an AVC type of a menu board speaker. If they're gonna use AVC, the AVC limits the output of the menu board speaker to 15 decibels above ambient. If this is the case, if you look at the memo that they submitted from the manufacturer and other documents related to the sound noise study, it clearly indicates, and I know this from previous cases, that if you have sound propagating at 1 foot from the source, if you get X, like at 2 feet, it goes less by 6 decibels. And then at 4 feet, it goes another 6 decibels down. And then at 8, every time you double the distance, it goes down by 6 feet. That means that if you want to get rid of the 15 feet that will be added above the ambient, that means you need 1, 2, 3 reductions. 3 reductions means going from 1 to 2, 2 to 4, 4 to 8. Theoretically speaking, if you're 8 feet away or about 10 feet away from the speaker, the 15 decibels that being added by the AVC system are gone, and you just get the ambient noise level. Beautiful. So if they're gonna comply with keeping that AVC on all the time, and we put this as condition, I believe the noise issue on this site is no brainer. So we don't have to worry about noise at all. That's what I wanted to say for now. Thank you.
So I think what you're basically saying is the location of it and everything would not result in a noise impact.
It shouldn't if they keep the AVC on all the time. Of course, if they don't keep the AVC on and they leave it to the guy inside and he raised the output of the speaker, they could go to like crazy levels, like 85 decibels or 90 decibels. If this is the case,
it should be kept to a fixed number.
No. AVC means automatic volume control.
Okay.
And what does, this is a sensor that's installed to the speaker. That sensor does like a variant, it reads the ambient level. Let's say the ambient is 40.
Understood.
You got it?
Yeah.
Perfect. I forgot to mention that the survey again is not legible in this case, and they need to give us legible one. Thank you.
Okay, thank you. Commissioner Shibeta?
Thank you, Vice Chair. I appreciate the comments of my colleagues. I have nothing further to add on this application.
Okay. Commissioner Yoon?
Hi, thank you. Just as you mentioned about the light levels, the only thing I wanted to add in addition to Commissioner Sheta's comments are that you can also use shielding on any light fixture as well as the overall height of the light source in order to prevent light leakage into adjacent residential neighboring properties. I think shielding can be a very effective way to prevent that bleed in those hotspots that were indicated. Thank you.
Thank you. Thank you, Commissioner Yoon. Yes, the light level is high along that edge. And while we do not have a number specifically, but I've come across numbers that says along the perimeter fence, and this is a study that was done for state of Washington. Now, state of Washington is different from state of New York and especially New York City. But in that it said along the perimeter fence, 0.5 foot candle max should be adequate. And what this study shows is more than that. So that's something the applicant should look into. And this is lighting the driveway, the drive-through, and that is before us. And that's specifically why we're picking up this issue. Okay. And
Vice Chair?
Yes.
Yeah, I just want to be fair to them. I didn't say that the lighting is high along the edge, the entire edge. It's just high at some spots, like 2 or 3 spots.
Right. And what you pointed out were the high points along the residential, which is abutting the driveway.
Yes.
Yes, that's exactly what thank you. Yeah. All right.
Okay.
Last
Move
case.
on.
Yes, please.
Final case, item number 36, 2021 70BZ, 1206 East 21st Street, Brooklyn.
Okay. We have proof of service for initial filing and hearing. We have a community board approval on this application. This is an application for a special permit pursuant to zoning resolution section 73622 to enlarge an existing 1-family detached residential home And the applicant is seeking a waiver of FAR, open space ratio, and rear yard. This is an existing interior lot with a 50-foot frontage. The existing building is a one-family detached 2-story building with a cellar and an attic. The applicant is proposing to enlarge it. The existing FAR is 0.55. The applicant is proposing to enlarge it to 0.56. And in terms of the demolition, the applicant is, which is one of the threshold, is to reach 50% of the existing exterior wall will be retained. On the second floor, 47.3% is proposed to be retained. So I think there is a way to easily accomplish 50% on the second floor, and I will get to that. In terms of the FAR, I think the ask is very minimal. I have no comments on that. In terms of the rear yard, the applicant is proposing to reduce the rear yard depth to 20 feet on the first floor, and while maintaining the existing rear yard depth of 28 feet 6 inches on the second floor. I'm okay with that too. Also, the rear yard depth study that has been provided for the subject lot, it varies. So it varies anywhere from 0 feet to 22 feet, especially where the apartment buildings are abutting the rear lot, to 16 feet to 31 feet, where their homes are abutting each other along the rear lot line. So I think what the applicant is proposing is to retain the existing rear yard depth on the second floor. I'm okay with that. While as I state, the ask is minimum as one looks at the entire build form and the FAR. While, however, to be consistent with the build context, I think the second floor should be set back and retain, and this would allow them to retain the existing front wall. So what the applicant is proposing is a double height living room. So that's the floor area deduction along the front. And what I'm recommending is the applicant set back the second floor, pick up much of the existing second floor wall. This would get to the 50% retention of the existing exterior floor wall along the second floor. And it would not result in any reduction of the floor area or the amount of floor space the applicant needs for its living condition. But it also would be consistent with the neighborhood context where the buildings all along this street frontage, the second floor is set back from the front yard, from the first floor, I'm sorry. And just in terms of the, just as an observation, I noticed that the bedroom number 1, it's the largest bedroom, so I'm assuming it's a master bedroom. It's kind of odd that the master bedroom is 8 foot wide, and it's about 17 or 18 foot long. But anyway, that's just an observation on my part. But those are my comments. Thank you. Commissioner Oakley-Brown?
I think this application is modest and I have no questions.
Thank you. Commissioner Shetta?
I agree, this application is very modest, and the only thing I would ask them is to add a dimension to show the rear yard on the second floor on the sectional and elevation views. That's all. Thank you.
Thank you. Commissioner Shibata?
I believe this is I second Commissioner Oakley-Brown and the rest of the notions. This is a modest ask. I have no further questions.
Okay, thank you. Commissioner Yoon?
Yes, I have no additional comments.
Okay, that wraps up our.
Sorry, this concludes the public review session, but do you want to add something, Vice Chair?
No. I think it is 12:14 p.m. So should we meet at 1 o'clock?
Okay.
That sounds good.
Okay, so we're going to, for anyone listening, including my interpreter, please don't disappear. We're going to take a break until 1 o'clock, and then we'll resume with the public hearing, and we'll follow the same schedule. Okay.
And just for a note to the commissioners, sorry, we received a DOT sign off for BSA calendar number 2014463 I think we know what the next step would be after that.
Thank you.
Thanks.
Thank you.
Recording.
Okay.
All right, it's 1 o'clock.
Let me know when you're ready.
I'm just scrolling to my notes. Okay, yes,
Ready?
yes.
Okay, good afternoon. This is the Board of Standards and Appeals public hearing for August 9th, 2022. We'll begin with the BZ calendar, continued hearing items. Item number 26, 2016-4463 BZ, 6202 14th Avenue, Brooklyn.
I guess this would be Mr. Goldstein.
Yes.
So while we're waiting for Mr. Goldstein to join, we
Hi.
have a, oh,
Just-
hello.
Listen, sorry. Continue, I apologize.
No, that's okay.
Let me swear you in.
Sure.
You affirm to tell the truth, the whole truth, and nothing but the truth, and you testify before this board and respond honestly to board member questions.
I do. Good afternoon, Jay Goldstein for the applicants. Madam Vice Chair, I believe you made a comment about the DOT sign off. I don't know if you want to preamble.
Yeah, I just, I think we have a DOT draft sign off. Is that a final one?
So,
I can
Yeah.
speak if, or
Yeah.
Jay.
Yes,
no,
please.
go ahead.
Okay, so we received the draft sign-off letter from DOT. Since we sent the draft sign-off letter, which a few hours ago, we received a new request for a different type of commitment letter to be submitted. And I guess it's a standard letter when you want to fund a signal construction as a private entity that DOT looks for this letter. The applicant already provided a different type of commitment letter. So we spoke to DOT and they said they would be fine as long as they get the this new commitment letter signed before they issue a final sign off. So I think we're comfortable with that. If the board is, that as long as we receive the commitment letter and the final DOT sign off, we can close today.
And from my standpoint, we're fine with, I mean, it somewhat echoes the commitment letter we already submitted. We're fine with that. I just couldn't turn it around, unfortunately, in the 20 minutes that DOT gave us. So we're hopeful that the board can close this hearing if that's their inkling, and that we'll get the sign off prior to any board vote for approval.
Mr. Goldstein, you've set such a high bar, even you are not able to pass that. 20 minutes, you can turn it around.
That was exactly, but yeah, sorry, I apologize.
So I think as directed and advised by Ms. Benke, I would be okay with closing it. But let's hear from the public. We still are in.
Oh, I have some other notes as well to share.
Please. Okay, sure.
So we will want to add notes to the plans regarding the DOT commitments and the e-designation language for hazmat prior to the vote as well. So we can work with the applicant to get that language added to the plans and request the e-designation number from city planning. We did have one question as well for the board. So DOT asked that a note be added on the plans a few weeks ago that all figures and illustrations are subject to DOT approval. So this was added to every sheet in the plans. So I don't want that to be an issue. If the board thinks that DOT might have an issue with that wording, if we need to limit it to just certain sheets on the plans. If you want to look at the plans, they were submitted on August 3rd.
Okay, let me just pull up the drawings. Just give me a minute. I am trying to. August 3rd plan. Okay, amended proposed plan. Yeah, I
Yes.
did notice the comments that were added.
Yeah, starting on sheet A1, it says drawings are for illustrative purposes only and will require DOT review and approval post BSA approval.
So now DOT is not reviewing every aspect of the plan. It is reviewing a very specific aspect of the plan, right?
Yeah, I
So
don't
the
think they'll be reviewing the elevations, for instance.
So just clarify what part of the elevation that would trigger a DOT review? Is it the building elevation or is it the site elevation or the elevation of the pedestrian?
Oh, I
ramp?
was just using that as an example of
To
what
clarify,
yeah.
Tracy, if I can jump in for 1 second to
Yes,
clarify,
please.
Madam Vice Chair. The note was added in response to a DOT comment, which said a BPP has to be submitted for their review. Obviously BPP is premature in this situation, so therefore they asked us to put it on the notes. I think what Tracy is asking is what plan sheet the board wants me to include this on. If just one, two, all of them, it's we'll adjust to the board's
I think it
desire.
should be, I don't think it makes sense to be, for it to be in the elevation, definitely not, because it could mean something else. At most, it should be on the site plan. And maybe if there is a DOT letter date that can be attached to it, that DOT letter dated blah, blah, blah. That way we know what is being tied to without saying too many words into the drawings. So at least we know where to tie the DOT's ask is with reference to the letter. Can that be done? I think site plan.
Perhaps the plot, they did mention the plot plan too. So
Yeah, so Tracy, we can amend it just to be on the general pages and not page specific. So the site plan, the plot plan, things like that.
Yeah.
Tie it to whatever the letter date was. No problem.
Yeah.
Sounds
And
good.
I'll work with staff to make that happen.
Okay, great.
Since it's relevant to the BPP, it's mostly about the sidewalk, the pedestrian, and that. So I don't think we need to have it on the second floor or any of the floors above.
Yeah.
Okay. Ms. Benke, is there anything else that you want to add that needs to be added to the drawings?
No, not besides the DOT and the e-designation. I believe there's no other conditions, but I'll confirm before with the applicant.
Okay.
So you'll coordinate with Mr. Goldstein in terms of all the additional notes that needs to be added.
Yes.
And do we have any notes from DEP?
That's I don't believe. Well, yes, that e-designation has met, but I don't think there's any air quality or noise notes.
Okay.
But I will confirm.
Did we ask for some window wall attenuation for some of the classroom windows that are facing the rear residential lot line? With the board, I'm looking through my notes. Now, Mr. Goldstein, do you remember if
I don't remember offhand. I don't think it was anything specific, but I know all the window wall attenuation is per seeker.
okay. And there is a rear yard, which will be used for children's play area. And there is a fence and that was studied by DEP. So any notes would be relevant that would be added would be whatever DEP would require.
Correct.
Yeah, we sent that a few times.
Yeah, it's been around for so long, trying to catch up at every piece of the puzzle.
Yes.
Yeah,
There's
think
also
we're
a restrictive declaration for bus parking, I believe, as well.
Yes.
Yeah.
Yes.
Restrictive deck and the lease that was submitted.
Okay. Okay. Should we then, are there any comments from any of the commissioners? Everybody shaking their head sideways, basically saying no. So
public?
let's go to the, yes.
So the case we're currently discussing is 2016-4463 BZ, 6202 14th Avenue, Brooklyn. Is a variance to permit a use group through school. Should you wish to discuss, please call 646-558-8656. Enter webinar ID number 834-2722-0881. Press the pound sign. At the next prompt, you will press the pound sign, then press *9 to raise your hand, *6 to unmute. And if you are in the Zoom room already, please raise your Zoom hand.
While we wait, Madam Vice Chair, to answer your question, we have notes on the plans for specific window attenuation for requirements. And we also have a note regarding that play area for the acoustic fence with the details and specifics.
Yes, I see that now. Yes, thank you. Yes.
Vice Chair?
Yes.
Yes, one of the comments I took back in the day when the case was like, at the beginning is no commercial catering condition. So I believe that should be a condition as well.
Yes.
Yeah, that's fine.
Yes, and I think interior yeah, if you could add it, just a note on in the cellar,
Okay,
and then that also will be a condition.
that's fine. We reference it in our statement of facts as well.
Yes,
So we're
you
fine.
do. Okay, so how long will it take for you to make all these revisions?
Within a week. So if we can get on September, that gives me plenty of time. And I would appreciate, I know September is tough, but anything we can do. I think this may be the longest running case in the board right now. So anything we can do to get rid of it is beautiful.
I agree, it would improve our staff. I have to look towards our general counsel and our executive director. Are we okay with adding one more item to the September? It would be we would close it. So it would be a decision, but that would mean writing a resolution.
Yes, I'm going to defer to council.
I haven't, thank you. I have no problem. Just let it be known that it be the last decision added to September. Thank you.
Got it. So you just
I
made
got
it.
him in. There you go.
Right. Thank you, counsel.
And we get to close it out right before the Jewish New Year. So it's beautiful. Works out perfectly.
Good luck.
So you do know the September hearing, I think the submission date is August
24th.
August 24th. So don't rush it. Be thorough, put all the comments in. We know you do. So please do that and submit it before August 24th.
Will do.
Okay. So I make a motion to close. Is everybody okay with it? All right. Make a motion to close.
Vice Chair Chanda,
Aye.
Commissioner Hartley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta, Commissioner Yoon.
Abstain.
Okay.
Thank you.
I just want to, if I may, I just want to thank Tracy and Jella for their work on this because the DOT and DEP aspect's been outstanding for a while and they really pushed it through. So I appreciate them and the rest of the board. Thank you very much, everybody. Have a good day.
Yes. Thank you, Jella. Thank you, Tracy.
Thank you.
Thanks.
Item number 27, 2021-71 BZ, 166 Coffee Street, Brooklyn.
Okay. I think, who do we have here?
Be me, and then there should also be Melissa. Not that there's anything to say.
Barbara Cohen.
Oh, and Barbara, yeah.
Yep, I'm here.
Hi. If she's
And-
not, oh, Aisley is from the same office, so we're good. All right.
Yes, sorry,
So,
my computer was simultaneous Zoom.
so
No
on the
problem, we have it.
screen, on the screen that we have Aisley there, we have Aisley and Melissa.
Correct. Yes, Osley and Melissa, yes.
Can you add both of your names?
Yes.
Just,
No.
thank you.
All right, everyone ready? Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to the board member questions?
I do.
Yes.
Yes, I do. Elise Fullader from Eric Polanic PC. I don't believe, we appreciate all of your comments. They were very thorough, and I don't believe you have any comments for us to respond to. But we have everyone here in case you do.
And that's much appreciated. I'm assuming no questions from any of the commissioners? All right, all sideway head shaking. Let's go to the public, please.
So the case we are currently discussing is 2020-71BZ, 166 Coffee Street, Brooklyn. This development of a 3-story single-family home with a cellar. If you wish to discuss, dial 646-558-8656, enter webinar ID number 834-2722-0881 and the pound sign. At the next prompt, you will press the pound sign. Then you will press *9 to raise your hand, *6 to unmute to be able to speak. And if you are in the Zoom room already, raise your Zoom hand, and that's the little hand that's the bottom of your screen.
Ms. Benke, are there any environmental outstanding issues on this one?
No, this is a type 2.
Okay.
And they submitted a new form that is acceptable.
Okay, so there is nothing, no revisions to the drawings are required. All great. So I think we'll wait for the public to call in.
One minute.
I think we can close on this, but I don't think we can schedule it for decision in September. As you heard, Mr. Goldstein took the last spot.
Yep.
So it will
So we'll
be,
take October 3rd if we can.
Huh?
I said we'll take October 3rd if we can.
Okay, we have 1 minute gone.
okay. All right. Mr. Vine, General Counsel Vine, you're okay with October 3rd?
Yes, October would be great. Thank you.
All right. Okay. Should we make a motion to close?
Motion to close, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Abstain.
Okay, thank you.
Thank you.
Thank you very much. All right, next case.
Moving along, item number, I don't have to mention it again, but in case anybody didn't hear the earlier, 2020-86 BZ, 15 Parkville Avenue, Brooklyn has been adjourned. The next item is item number 29, 2021-40 BZ, 157 West 24th Street, Manhattan.
Okay.
This is Ron Rosati.
And Ms. Cohen also.
Barbara Cohen. Who else is with you, Mr. Rosati?
Simon Lee, the architect, I believe, should be joining.
Simon, right?
Yes, Simon Lee.
don't see him.
Mr. Rosati, I don't believe we have a Simon Lee in the waiting room, but if there are any attendees in the waiting room who are participating in the applicant team, please raise your Zoom hand and we will admit you.
Don't see it.
I think most of the comments were financial related. So if he's not there, and we could start if the board wants.
Okay,
Okay,
raise the
let's
right hands, Barbara and Ron. Unmute Barbara, sorry. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board to respond on the city board member questions?
Yes, I do.
Good afternoon, commissioners, Madam Vice Chair. Heard the comments earlier at review session. Regarding the D comment, the self-created hardship, we will submit a tax map from 1955 into the record, and that does show that the subject site has not been altered since at least that time. So there has been no self-created hardship here. And the financial comments, I'll turn it over to Barbara to address.
Okay, thanks. So the two main issues had to do with the site value, and I apologize there. I misread the city planning website and got confused with the citywide hotel text amendment, which is 2021 versus the M1 hotel text amendment, which is the 2018. So I will go back, do the research and make the adjustments based on that. That's one thing. The costs. I also realized that on the as of right office, and I don't know if I can share the screen or Commissioner Sheeta can bring up what he was pointing to. There's a page missing, and I'd like to sort of also walk through and talk about how it's all done and how the geographic factor and the inflation factor come into play. This came up in terms of the inflation factor, came up in another case, and I did go back to Marshall and Swift, and in fact, in section 10, it describes how the book version does take into account inflation with every month that they update it. But let me sort of walk you through a little bit on the commercial office. So
Ms. Cohen, do you need my screen?
Well,
No, we have something on the screen.
actually, if I can share the screen, maybe
Sure.
that would probably be best.
Good.
Share screen. Let's go there and here.
Long case.
Okay. Hopefully you can see that. Let me just widen it out a little bit.
Ms. Cohen,
Yes.
which page are you referring to?
Well, I'm gonna show.
But this is a different document, set of document. It's not before us.
No, well, it's a combination of both, but what I'm gonna do is talk about a couple of things. One, the class of construction, which is what's up there in front in terms.
Chase, sorry, Vice Chair Chase.
Hi, just for our record, Ms. Cohen, to the extent that you will be sharing anything on share screen that has not been formally submitted into our record, please make a formal submission, coordinate with Mr. Rosati to make a formal submission into the record of any material that will be displayed on the screen that hasn't yet been submitted.
Sure. I just thought I'd use it now to sort of explain the differences between some of the comments had to do with the class of construction in terms of fireproof, not fireproof, steel versus concrete, and the other the category of quality, average, good, excellent. So I was just going to, but I will, in the next submission, put all this in order to provide the support. Should I?
Just to clarify, I didn't raise an issue with the class. The issue I raised was with the same exact pages you submitted. And if you can take your screen off, probably I can explain it.
And I just say, I had raised the question about the class.
Oh, okay,
That's
sorry.
what Ms. Cohen's responding to. Am I correct?
Yeah, so we'll do the class. So the class has to do with the structure, and it has to do with whether it's structural steel or concrete. And the project architect will clarify as to what type of framing it is, and we'll adjust it accordingly to either be a class A or a class B, which is the difference between steel and concrete. And
you have it as an A now.
Right. So if it's concrete and it's fireproof, then we'll go to class B. Okay. So that's the first sort of decision you kind of make, right? The next issue is the quality of construction in what you pick, whether it's low, average, good, or excellent. And the issue there was I had both as average A, both I think the as of right and the proposed. And there the question had to do with the extra costs related to the condo project requiring better finishes and so on. So I had average. It states that it's a standard construction with simple ornamentation and finishes. So my added cost, I think, is appropriate because it provides that extra. Now I could go to
question.
Yes,
yes. You're talking now about the proposed. You jumped to the proposed?
Yes, sorry. Yes.
All right, so it wasn't the average that I was objecting to, it's the luxury. You used the luxury table.
Right, but it was
so the luxury
I'm going to go back and
table,
distinguish whether the word luxury and average, whether luxury takes into account that extra or whether it's the average.
It says, if you look at the luxury apartments high rise interior finish for both A and B, good is finest interior detail hardwoods, and good is good interior detail carpet, ceramic tile, vinyl, and fine hardwood.
Right.
Electrical, plumbing, fine fixtures, one full bath per bedroom. So it seems to me that you're taking into account a better level of fixtures than you would with just apartments when you go to luxury apartments. And that's why I was objecting to the additional add-on.
But is luxury average? I want to go back actually to look up what they say. What's the difference between high rise and luxury high rise? Because they distinguish obviously between average quality and fixtures versus good quality. So I'll go back and see what those differentials are, and not double count. So that takes care of the sort of two categories there. What would the page that was missing in the commercial was this page. So Commissioner Shita, you were pointing to retail, and the reason why I had the retail sheet in there is because in the proposed there's retail space, and it's not fitted out as residential space, so you make a deduction, and so you use that page to do that. But the page that was missing was this page, which is the office building page. And you see the 209, and I'll move it over. So the average A, brick, concrete, metal and glass panels, little trim, all the way across, that's where the 209 comes from.
So you're saying it was a missing page in your submission?
Yes.
Okay.
So
I'm fine with that.
Yep.
Is this the same exact that you submitted to us?
No, this is the page that's missing. That's why I'm.
No, I understand, but this is the same document I'm saying.
Yes, I just pulled in this page to the document.
Can you go back to where the breakdown for the as of right is?
So here it is.
Yeah.
Okay, so what you see there is the 209 and you
209,
see
yes.
section 15.
Why does it say 118 West 28th Street?
Good question. Sorry,
Sorry, that's a typo, right? I'm assuming that's a typo. Sorry, didn't mean to
yeah.
interrupt.
Too many close proximity projects. Anyway, this will get all cleaned up. But the 209 is actually used in both, but.
Thank you, Tony. Can I point to something?
Sure.
And we did discuss this, if you recall, like a month and a half ago, on 2 consecutive cases. And you said you made a mistake. I recall that.
That's
You see
in the cellar, you mean? Or
you got it. You actually, you mentioned it before I start talking about it.
yeah.
Can you go back a little bit to the 209?
Yeah.
The way it's done, and I did contact Marshall and Swift on this, and they confirmed that. And I did put emails from them on the screen before. When you do the Cellar, it's not an add up to the 209. Just to be clear, the Cellar cost is much less than the superstructure. And the way it's done, can you go back in your submission, please? Go back, sorry, go down. Yeah, one more page. There is a page for the basement.
Yes.
Yes, next one.
So, and I looked up in the section 2 that, and it said for the multi-story buildings.
It's not an add up. There is a page that you submitted for the basement, and it gives the price for the basement. I can see it. If you give me the screen, I can share it from your submission.
Yeah. Okay.
Can you, Commissioner Shetta, what is the page number? Maybe Ms. Cohen, you can pull that up.
54.
I stopped the
It's
share, but I know
page
what you're
54.
saying.
One person talking.
Hold on, Commissioner Oakley Brown.
It's page 54 in the financial report is where they have the breakdown. You have the breakdown, rather.
So I'm not talking about the breakdown, Commissioner. I'm talking about page 63. And again, if you give me the screen, I can, yeah, I got the screen. Hold on. Yeah, I'm talking about this page. You see this page here? This page gives the cost per square foot for cellars.
Yes.
And for a basement, if you're talking about A or B, and you're talking, let's say, about a parking, the cost should be $60. It's not 209. Let me go back to.
No.
Yes. Go ahead. You want to say something? Go ahead.
So, yeah, I looked at, there's a pages in the front of the book that speak to the basement and the idea of calculating it separately and adding it on. And it speaks to multi-story. When you do multi-story, you do add it on. You take, in this case, you're looking at the residential, the basement is the 52. It then gets divided by the, multiplied by the area of the basement and then divided by the overall above area square foot to get the price per above area. And it is added.
What kind of use in the basement? What is the use for the basement?
I think in this case, it's storage. I think the plan used to be half residential, but now it's storage.
Excuse me, Chase is saying the architect is in the room, so I have to swear him in. Mr. Lee?
But again, in the next submission, I'll support the, all the moves that I make.
I thought we passed this. I thought we discussed this before with Marshall and Swift. We get a clear-cut response from them, and you voted before.
No, it was really on the case on 28th Street where all of this was discussed and maybe a prior case, but we haven't come back to a public hearing where we, totally go through it. And I thought, but I wasn't, I looked it up and I know that the pages say not in a multi-story, but I'll go back, you go back and we'll come to the determination on that. What I wanted to just do lastly.
Can I just jump in?
Sure.
I think in the interest of time, and I know I don't want to go back and forth on this. Best would be, Ms. Cohen, if you go through this particular sheet and identify what actually is factored in for a multi-story building and how Marshall and Swift, what Marshall and Swift considers residential units to be with a finished basement, and how that is parallel or not equitable or equitable to a multi-family dwelling unit. You need to clarify that, because it's not, I mean, when I'm reading the class A, B residential unit, it says kind of things that can be used is, it seems to read, it says 1 bath per unit. We don't allow any bathrooms or any, I mean, if it is, it would be for commercial purposes, but not for residential purposes. So again, it's, I'm just looking at what kind of fixture and what you can have. Few electrical fixtures, average plumbing, 1 bath per unit. But that's for the basement high rise. It's a little confusing for me, I'll grant you that. So it would be very helpful if you can provide an absolute clarity in terms of what Marshall and Swift analyzes and assumes for a multi-story residential building with a commercial use on the ground floor.
So there is actually a whole section that gives an example of how to use all the parts. I can certainly do that. The only other thing I was going to speak to was the inflation issue and how that is dealt with, and that's because there was a discussion in prior hearings during the case that the comparison between online not showing it and the book showing it. So every month I get a CD, it's the entire book. The sections for the different types of occupancies have dates on them and they're different. So if you look at the residential sheet, you'll see it has a different date up in the corner. Every month, they give you a new sheet, which is that section 99, where it says, here's the new inflation factor that goes with a section with a certain date. Are you still sharing screens? No. So that inflation factor comes into play every month, and that's true of whatever use it is. You go back, you say the residential section is dated X, you go to the new monthly sheet, it says for an A, B, or C, for a section that's dated X, you add the factor that is said. Geographically, it indicates the county. Again, it's either an A, B, or C class, and you assign the factor there.
Does it change within the city? That was my point.
Between the counties, they distinguish, yes.
Not counties, within the city, between boroughs.
Yeah,
Yeah,
that's
boroughs.
what she means by county.
Right, New York County, Kings County, Queens
Bronx
County.
County.
Yeah, right.
Okay.
So that's, but there's 2 things I can do. One is I'd like to send the examiner so the entire PDF so that you really have it in hand, so that you see all the sections and all the explanations and the examples. And then I can do a separate maybe memo to sort of show how it works.
That would be helpful.
That would be very helpful.
This way, every report doesn't have 50 pages of appendixes and only the appropriate, pages for each development. So,
okay.
So I think that's it. I mean, I gotta obviously go back and make it all right, make it all fit, consistency, cleanup.
Missing pages.
And missing pages. And make it as beautiful as all the other reports.
Ms. Cohen, I think what you're suggesting is going to be very helpful for the board, providing the PDF and an explanation of how to put this puzzle together for different cases. So that would be enormously helpful. So thank you for.
It'll save time later on.
Yes, especially I can see it will benefit us for sure. Commissioner Otley Brown, did you want to say something? Because as I was saying something, you wanted to say something.
No, I just wanted to say that I don't think that Commissioner Shetta was questioning the cost of the basement. He was questioning what he questioned before, which is when you're doing the manual calculation.
Yeah.
Because if you're doing the online calculation, it does it automatically. But what he was saying is when you were doing the manual calculations, you have to be careful that you cost out the basement and then divide it by the above ground square footage, then add that final factor in and not the factor that is indicated on the paper, because that's higher because it's just for the basement square footage. So like, I think that the questions that we are asking, some of the questions have to do with the fact that Ms. Cohen is doing paper-based manual calculations versus having the online program that automatically figures that out. Correct?
Correct. And I prefer the paper because it gives all the background as to what things mean, and it to me it's more helpful. It's no different in terms of the inflation issue. It's still up to date with every month that they provide that update. So it's the same.
But again, I just want to be clear. I'm not asking you to use whether the manual or the online. It's up to you. But what I'm asking is you do it right, whether through the manual or the online. And what I did last time in the two cases that we looked at, like consequently, that I took an example and I sent it to Marshall and Swift, and later on we discussed this. What you're doing right now is you're making the cost for the seller higher than the cost for the superstructure, which doesn't make sense. That's why I'm struggling with this.
I understand. And then on two of those things, well, one, it was just a mistake. It wasn't divided properly.
Okay.
So.
Okay. So I think we have asked all the questions from Ms. Cohen. Mr. Rosati, who should from your team speak now? Thank you, Mr.
Thank you, Barbara. I don't think we have anything else to add at this point, if you want to take public testimony.
Okay. Right. Let's go to the public.
Okay, now we'll go to the public. Sorry. The case we are currently discussing is 2021 40BZ 157 West 24th Street, Manhattan. Should you wish to discuss, you can dial in 646-558-8656. Enter the webinar ID number is 834-2722-0811. I'm sorry, I apologize. 834-2722-0881 and the pound sign. Then the next prompt, you will press pound. At the next prompt, press *9 to raise your hand, *6 to unmute to be able to speak. And if you're in the Zoom room already, raise your Zoom hand, which is the little hand at the bottom of your screen. Once you're in the room, we'll give you 3 minutes to speak.
Okay. I'm assuming somebody's monitoring who is calling in.
There are people in the room. Can the host let them in?
Yeah, let in 2 people already, like had their
Okay.
hands up. Yeah.
I don't have that screen. 1 second. Let me go back to that screen. Okay, thank you. Okay, so Ms. Shanahan and who's the other? Sarah Mueller, I know is Sarah Mueller. Okay, and Marie Shanahan. Which one do you want to start with, Vice Chair? Sarah Mueller?
In the order of whoever's.
Ms. Mueller,
called in
you want to
first.
start first?
Can I just say?
I'm sorry, can I stop you for a second? Are there any electeds? Anyone representing an elected? Nope. Okay, Ms. Mueller? Just
Can
want
I,
to
we have some people trying to call in on the phone line.
I know they're having a little difficulty.
I
was
know,
just-
and they're on bigger time crunches, so I'd like to let them go first, if possible.
I don't know. I don't see them calling in.
They're
There's
trying.
one,
I
Yeah,
know
but
they're
there's 2
trying.
people, Yeah.
Do you know, Miss Mueller, do you know the last digits of the phone number so that we can locate them?
That they're calling from?
Yeah.
Yeah, hold on, please. I'll look that up. Hold on. Sorry.
Yeah, they contacted Manny. I gave them the information. They said they were trying to, they're having a little trouble getting in.
Hold on. So the last 4 of one of them is 3344. That's Jeffrey Liu.
That's the one who's having trouble getting in, Mr.
And
Liu.
also we have Jennifer Chang, and her last digits are 5226. And they're both on time crunches. There's a whole bunch of people trying to balance their own meetings today.
Could we put the call-in information back on the screen, please?
Yeah. I gave him the call information. I don't know what's happening. So you can dial in at 646-558-8656. It's on the screen here. You'll enter the webinar ID number 834-2722-0881 and press the pound sign. At the next prompt, oh, go ahead.
Go
You
ahead,
wanna
go
say
ahead.
something? I'm sorry. Press the pound sign at the next prompt. Okay. And then press star 9 to raise your hand, star 6 to unmute to be able to speak.
Is James Chin one of them? I see James Chin.
No, that
No.
might be for another case.
James is part of our applicant
next
team,
case.
but he
Oh,
does.
James
but
is
he doesn't-
there, yeah.
Yeah, but he's not going to speak.
Right. Sorry, Ron. Forgot John, James in.
Anne Marie, I believe, has a meeting
Um,
as well. If she wants to go first, it's fine with me.
Okay, thanks, Sarah. I'll jump in if that's okay.
Yeah, you'll have 3 minutes to speak after
Oh.
you start your name.
Okay, hello, Madam Vice Chair. My name is Anne Marie Shanahan. I am a resident of 159 West 24th Street, which is directly next door to the proposed project. I'm also the president of that building's condo board association at the Carriage House. I've been the president of the board for the past 10 years. And I wanted to briefly speak here today as a representative of the 24 families that live in our building. Like my neighbors that will speak today, I'm not a zoning expert or an attorney. I also did speak when we first presented a few months ago. It looks to me that this revised proposal of a 12-story tower still doesn't seem acceptable for such a narrow lot. It would still be out of context with our near uniform 78-foot roof line. And I also believe that it remains in violation of the sliver law. I also wanted just to note that the Carriage House building that is next door was built in the 1900s. It's only 8 stories tall. It has a beautiful roof deck that is shared by everyone in the building. Clearly, if a building were to go up to 12 stories, it would have impact not only to the light, but to our building there. So it's my hope and that of the 24 families of 159 West 24th Street that the BSA not grant a variance for the project to be a 12-story building at the expense of our neighborhood. And I thank you for allowing me to speak today.
Did you say it's a landmark building?
No, I just said it was, no, a historic, it was built in the 1900s, but not an official, I don't believe it's an official landmark building.
Thank you. Thank you very much.
Okay, Mr. Lou, if you, Jeff, is that Jeff Lou, 344? Could you unmute? Because I know you've been waiting and trying to get in. Can you unmute? The one who has last numbers 344?
Press *6 on your phone to unmute.
*6, yeah, sorry. Thank you, Chase.
Hello?
Hello, Mr.
Hello,
Lou.
could you-
Thank you for your patience.
Oh, thank you for all of your hard work here. I just want to say that I'm speaking on behalf of the 33 families that live next to Emery's building, which is the corner building at 245 7th Avenue. We've been watching this unfold over the last year or so, and we were very present in the last meeting, and I echo what was said previously by my colleague next door in that this 12-story building is clearly not compliant as what was suggested by your board at the last meeting to come back with a compliance solution. It seems that their 6-story option is more compliant with the civil law. And I also want to point out that a 12-story building would be the tallest building in the whole group of North Side historic properties. They're not landmarked, but the whole block is built with historic buildings from the 1800s and even early 1900s. And we really hope that and appreciate that the board is looking at this very seriously and forcing or hopefully forcing compliance with the appropriate laws that protect the neighborhood, the character, and mostly the law as it relates to the zoning and the allowability of tall structures in mid-block areas. So I just again want to reiterate our 33 families' opposition to the 12-story option.
Thank you.
Thank you.
Next.
Ms. Mueller?
You said, okay, my turn.
I don't see anybody.
Jen Chang is not on board.
Is that 920, the last number? I don't have 5526.
Yeah, that was.
I don't see it,
Okay.
Ms. Chang.
Okay. All right. So if it's my turn, I'm happy to speak. All right. Hello, commissioners. My name is Sarah Muller, and I'm the vice president of our board at 245 7th Avenue. That's 2 lots from the site. And today I speak on behalf of 33 families. I'm here again to urge this board to deny this outsized variance for a 12-story tower unless the height is substantially reduced. While this developer took the performative action of reducing its scale from 15 stories to 12, the fact remains. A sliver tower this big, this tall, and this out of place would stick out like a sore thumb and destroy the essential character of our mid-block streetscape. It would also harm so many of us by permanently restricting to light, air, and sky, shadow, and have a detrimental impact on West 24th Street.
Ms. Mueller.
As I testified back,
Ms. Mueller,
Yeah.
Ms. Mueller, we had a little bit of a cutoff. We didn't hear a
Oh.
bit of what you said, like the tower, the sliver tower not being in context. You froze, so we missed from that. Can you start from that? Where you we heard you till sliver tower not being in context. Just pick
Okay,
it up.
yeah, okay. Well, I just was saying that it would harm so many of us by permanently restricting access toward light and air and sky and cast a permanent outside shadow and have a detrimental impact on West 24th Street. As I testified back in April, what's so nice about the mid-block section here is the consistency of style of old lofts and the consistency of the roof lines. Right here, you can
We
see.
can't see that clearly,
Yeah,
unfortunately.
well, it's submitted in my letter. The heights range from
Okay.
33 feet to 97 feet, nothing near 117 feet. That's 57 feet higher or nearly double the 60-foot cap that would be applied under the city's sliver law. And as Vice Chair Chanda pointed out in the review session earlier this morning, because this is a residential property and it's on a narrow street, sliver law applies, which would cap the building height here to 60 feet, not 117 feet that they are seeking to build, nearly double what's allowable. Speaking to sliver law, it was designed to protect, preserve, and maintain the neighborhood character under the city's own zoning code. And back in April, this developer was told to significantly reduce the scale of the building and pack the bulk lower, but they're still asking for something that's nearly double the height of what's allowable. And I don't see how the BSA could approve a variance for a residential sliver tower that's in direct conflict with its own regulations. Additionally, as Commissioner Shetta pointed out earlier today, this developer is trying to get the best of both zoning codes. They want the height that would be granted for, say, an office tower in the manufacturing zone, and they want to build residential, which requires them to stay low. The reality is they can't pick and choose only what's favorable, the favorable sections of the zoning code as it applies to them. And sliver law applies to a residential building that they are seeking to build. To me, what this developer is asking for is greedy, and the BSA can't find this variance acceptable based on their own guidelines. It's something that's out of place and will destroy our essential mid-block character, and it will also be in violation of sliver law. Thank you so much for listening, and thank you for your consideration.
Thank you. Okay, is there, okay, I'm sorry, you had a question.
Are there any speakers?
That's what I was just gonna say. Is there any other speakers for 157 West 24th Street, 2021 40BZ?
Press *9 on your
9.
phone to raise your hand, or use the Zoom raise hand feature if you're in the waiting room and would like to speak on this. We have an additional phone number in the waiting room ending in 226.
Okay. I'll just give another.
Wait a minute, I think that might be Ms. Chang. Please *6 until mute.
Hi, Commissioner. Thank you very much for providing us this opportunity to speak. My name is Jennifer Chang. My husband raising us 3 young kids at 240-5 7th Avenue, which is just 2 buildings away from this proposed sliver tower. I also have been following this very closely since 2017. Spoke during testified back in April. I speak on behalf of the other 30 odd units in our building at the Chelsea Atelier, in that this sliver tower would ruin the neighborhood feeling, with block access to sunlight and views, as well as just the plain fact that it does not observe many of the building codes and regulations that it should. Unfortunately, my son is behind me, a little upset right now, so I'm not able to speak a bit longer, but just wanted to voice my opinion and let you know, and let you all know that we are very much against this, and I appreciate you taking the time. Thank you.
Thank you.
Thank you very much for calling in and tackling your child at the same time. Much appreciated. The time that you all take to listen in and share your thoughts and concerns. I think it's important for all of us to know that for those who are on the board. On the record, I just want to make a couple of statements. Want to correct a couple of statements. First of all, I never said that an R9 building, R9X building is permitted as of right. It is not. This is a zone for manufacturing. The case is before us because of the following factors. This site is zoned for manufacturing use. So only manufacturing related uses and commercial uses and select community facility uses are permitted on this site. The site also is a very narrow site. It's a 20-foot wide site, 100-foot deep. And the applicant went through its as-of-right analysis to show how if an as-of-right building were to be permitted on this site, which would be a commercial office building, how it would result in floor plates that would almost have very little footprint after you deduct the perimeter walls, after you deduct all the vertical runs of an elevator, staircases, mechanical runs, everything. It would leave very little footprint, rentable space. And that is for a commercial office building. And a commercial office building would be permitted to have a maximum of 10 FAR, and there is no height limit. So it could build until it exhausts the height. So assume, let's say, I don't know, it will definitely be more than a 10-story building to maximize the full 10 FAR. So the applicant went through that exercise of the as-of-right development to show how an as-of-right development is not feasible, and therefore is looking for, and this is where the variance comes in, the applicant has to go through each one of those findings to identify, this is a unique site, which the board agreed based on the analysis that it was a unique site, and that the narrowness of it and the zoning district, their combination of the use limitation does make it difficult for the developer to have a financially viable or reasonable project. And that is the exercise, second part of the exercise that we are all going through to make sure that the project is financially reasonable. And that's why all the financial analysis is being looked through with a lot of details by our commissioners. Now, what we did ask the applicant to do is that if the applicant is proposing a residential development, which is not permitted as of right, that's the use variance the applicant is seeking, then the closest zoning district the applicant can replicate is the closest residential district that the applicant can replicate is the zoning district that is nearby, which happens to be a C6 3X zoning district, which is the same as an R9. I think it's R9X zoning district. So what the applicant, at the last hearing, we asked the applicant to use the R9X zoning district FAR, which is 9 FAR, not 10 FAR, and then try to use a street wall building. The initial proposal was a building that was set back from the property line. And we absolutely recognize, as the community board has stated, as the speakers here have stated, that there is a very unique street wall context on this block front. And then we directed the applicant that they maintain a uniform street wall along this block frontages. So that meant the building had to come to the front, maintain a street wall of a 6-story, which is what an R9X would require. And then the building would have to set back, in this case, it being a narrow street, a 15-foot, and then go higher up. But we also told them that if, based on the financial, it does not mean that you will get all of the 9 FAR. If you meet the financial requirement, then only that FAR that is proposed, it will be considered. If that the minimal return can be gained through a lower FAR, so be it. Maybe the height comes down, but that's for the applicant to prove. What we are here basically saying that there is a neighborhood context, and that neighborhood context does lend itself to a uniform street wall building with a setback and with some height above it. And what is that height above it is the debate that is going on amongst the commissioner. And at no point did I say that R9X is an as of right use here and an R9X FAR is going to be applied. No, and the sliver lot does not apply in a manufacturing district. So what we had asked the applicant was, if it were an as of right R9X on a 20-foot lot, narrow lot, how would a sliver lot building look like? And the applicant provided that information. And we had asked the applicant to pack the bulk as much as possible so that the building can be lowered. So those were the guidance we had, the board had provided at the last hearing. I'm stating this on the record so that everybody is very clear about the direction that the board had given and what, and it is important for us to hear what the community is saying. And we heard that, and that is one of the reasons why the street wall has been pulled to the front to maintain a very uniform street wall here. So I thank you again for your continued participation and your involved, detailed, diligent review of the case and feedback. So please do stay tuned. We are not there yet. We have, the applicant still has to respond to the questions and comments that are there. They have not met the findings B, and that affects to a large extent the finding E, which is the minimal, and that would determine the height of the building. Okay. Did I leave out anything, commissioners? Okay. Applicant, who from the applicant should be stepping in?
Thank
Mr.
you.
Buddy?
Yes. Hi, thank you, commissioners. I'm going to defer to Barbara as to how long she needs to respond to the financial comments heard today.
I guess 2-3 weeks, just because I got to get other things done, but pretty short order.
So, Mr. Rosati, you gathered what I was saying. You still have not met finding the E finding, and that and to a large extent that relies on the financial. So, if the financial is not met, it would result in some changes in the plan. So I just want to...
Understood. Thank you. So we asked for 4 weeks for submission.
Okay. Definitely it's not going to be the September hearing. It's going to be one of the October hearings. We will get back to you on that.
Okay. Thank you, commissioners.
Okay. Any other questions from the commissioners to the applicant? All right. Thank you very much for being here. Thank you, Mr. Rosati, Mr. Cohen, Ms. Cohen, I'm sorry. And next case, please.
Item number 30, 2021-64 BZ 205-207 Graves Neck End Road, Brooklyn. This is Lyra Altman.
And I think Mr. Vincenti.
Mm-hmm. Sorry, I'm in panelist. Should be a panelist. I don't see Lyra. Okay, here she comes.
Tony, can you hear me?
Yeah. Do you have a photo? Please join. Accept it.
I know my video tends to in and out, so I'm going to wait to click it until we know we have our architect on. Sal Vincenti, is he here?
Yeah, he's there, but he has to unmute. Mr. Vincenti, unmute.
Yes. Hi.
Photo. Panelist, please. Please join as panelist.
Okay. Hi, Sal.
Here we go. Yeah. Okay, raise your right hands. Please join. Accept it.
I know my video tends to in and out, so I'm going to wait to click it until we know we have our architect on. Sal Vincenti, is he here? Sal, turn off your YouTube.
Turn off your YouTube, Valera.
Oh, mine's off. Sal, turn off your YouTube.
Yes.
Photo. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond to the board member questions?
Of course.
I do.
Before we start, there's something I omitted at the review session, and I want to take this opportunity to clear the record. And one of the things, and I want to thank Council Vine for bringing this to my attention. At the last hearing, the question was brought up about the housing typology. So this is, as it stands, is a zero lot line building. And the special permit does not apply to a zero lot line building. And that's a basic threshold. And, this is the fact that the lots have been merged. It's still a zero lot line building, and we cannot assume it will be semi-detached once the building next to it is built. And I'm not comfortable applying the special permit unless you get a zoning determination, that the building as it stands today, the zoning lot as it stands today, and the building is not a zero lot line building. Then only section 73-622 applies. Am I, Mr. Vine, Councilor Vine, is there anything that you want to add in?
Yes, Vice Chair. I also want to add that the ZRD one into the record on July 21st regarding lot modifications was accepted by DOB with conditions. One of those conditions be that an easement agreement between lots 5 and 4 for the driveway and off-street parking be filed, which and zoning lot 5 be labeled as accessory recreational parking spaces for lot 13, which would essentially limit development on that adjacent lot, such that, correct, it could not be then considered as a semi-detached dwelling.
So that therefore makes it a through lot, that therefore makes it a zero lot line building and not a semi-detached building. Because if that lot, if the abutting lot is going to be used as a yard, parking lot, no development can happen. Therefore, should any development happen, again, I find that argument, we cannot assume what can be built, right? One can choose to have a detached building also. Or they could merge the lot with another lot and can have large enough lot to have a detached building. So there are a lot of assumptions one can take in. And the fact that the buildings department condition is that it remain as a parking lot, it therefore makes this development and the existing building on this combined tax lot into a zero lot line building. And section 73-622 does not apply to zero lot line buildings. So you need to get a read from DOB on this one.
Okay. Okay, we'll do that.
We certainly can't do that, of course, before today's hearing, but we'll be glad to do that.
Right. So I am, in the interest of everything, do you think it makes sense for us to proceed? Because that's such a basic threshold question. I think all our other comments would be moot. But
sorry.
I think, let's put it this way. You have heard our comments, right? We didn't have any issues with the proposed design. Should this be considered as a semi-detached building, right? So it's the clarifications are more of, what am I missing? The predominant built up, that's another basic threshold. A note is not adequate. As you know, we have always asked for an analysis of the predominant built up. If the 1.35 FAR of an R4 in a predominant built up is being applied, then that needs to be shown. Otherwise, you have to provide a FAR analysis of the neighborhood to show how the existing not predominantly built up FAR is the proposed one is consistent with that. So I think there are two threshold factors that needs to be addressed, and I don't want to take too much of this time and go back and forth in our discussion on the predominantly built up. As you know, that is a very standard ask that we have asked all throughout.
It's our pleasure to provide that analysis for you for the predominantly built up and to go to DOB to address this other issue that just came up.
Got it. And with that also, just to package it in, should everything move smoothly the way you want it, also then provide the easement, the parking easement, all of that. But we need to have all of those answers in place for us to consider it.
Okay, understood.
Okay. Any questions or comments from the commissioners? Council Vine, anything? Okay. Let's go to the public. Oh, sorry, General.
I would just add that with respect to a DOB determination that this is a semi-detached or detached dwelling, which are both eligible, both housing typologies are the special permits available for both. And please refer to the definitions under 1210 for detached, semi-detached, and zero lot line building.
Right. And you may want, if you want to, you can run the ZRD one with our general counsel before you submit to DOB. That way, you know, if anything got missed, you can pick it up, and that way you don't have to go back to DOB again. You know, if you do want to make it, if you want to come back and you want to make it, make the zoning applicable, the special permit, you can always take a portion of the building out, but that also makes the building, the 50% an issue. So there are lots of little pieces. So
We're aware.
yes, so please think this through and look into this.
We'll be glad to.
Okay, thank you.
Okay, go to the public.
Yes.
So the case that we're discussing today is 2021-64 BZ 205-207 Graves End Neck Road, Brooklyn. Should you, this is an enlargement of a single family home. Should you wish to discuss, please dial in 646-558-8656. You will enter the webinar ID number is 834-2722-0881 and press the pound sign. At the next prompt, you will press the pound sign. Press *9 to raise your hand to speak, *6 to unmute to speak. Sorry, raise your hand. Notice, then press *6 to unmute to be able to speak. If you're in the Zoom room already, please raise your Zoom hand. Once you are in, you will be given 3 minutes to speak.
Okay, so while we're waiting for people to call in, public to call in, how long will it take? I know it takes about 3 months for ZRD, so.
Sal, I have to defer to you on this since you go to DOB.
Let's just review it and then perhaps we can make that decision.
Okay, we'll get back to you with a date.
Yeah, I think you need a lot of time. I'm looking more like somewhere in November or December for this one.
Okay.
But do get back to our staff.
We will.
Thank you. Sorry about this. I should have picked it up at the review session.
It's okay. We couldn't have gotten it from an hour ago anyway.
Fair enough. Okay. All right. All right. So back to the drawing boards.
Yeah.
Please get back to us. Thank you. Next
Oh.
case.
Okay, item number 31, 2021-67 BZ 2307 Ocean Parkway, Brooklyn. Are you here by yourself or with Sal just dropped off? Lyra? Lyra, that's your case. Could you call in again? Sorry, what you do?
That's odd. It blinked out. I apologize.
Weird. Are you by yourself?
No, Sal should be here as well.
Salvatore.
I don't think we need
I was gonna say, we don't really need him, but he was gonna log on anyway.
Yeah. Okay, let me swear you in. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Of course.
Please go ahead, Ms. Altman.
Based on what we heard at executive session, I don't believe there's anything to address unless something else has come up.
No. I only do one case at a time. A week. All right. Well, let's go to the public. Does any commissioners, do you have any questions? Okay, none. Let's go to the public, please.
Okay, the case that we are currently discussing is 2021-67 BZ. This is a special permit for home enlargement. Should you wish to discuss, dial 646-558-8656. You will enter the webinar ID number is 834-2722-0881. Press the pound sign. At the next prompt, you will press the pound sign. Press *9 to raise your hand once you're in the room, *9 to raise your hand, *6 to unmute to be able to speak. If you're in the room already, please raise your Zoom hand. And that's the little hand in the back on the bottom of your screen. What time is it?
I think there was nothing to submit on this one.
Double check.
And we are all good on the environmental. So
Type 2.
Type 2, right.
Satisfied. No comments.
All right. Enough time has gone by.
Give it one more second, a couple minutes, a couple of seconds. Okay.
Okay. So there's nothing to submit. We, unfortunately, even if we close it, we won't be able to make a decision on it until October. Well, I see our executive director's hand up. Yes, Mr. Costanza.
Yes, for Ms. Altman, is there any concerns of decisions in October? For a decision date in October?
Oh, for my purposes for calendar, I can tell you, bear with me a moment. I'm just going to look at the dates. There are some October dates that are an issue at the moment.
Yes.
Since
Okay, thank you
October
for
4th
pointing
is
that.
out.
October, I have to look at the October calendar. I apologize. I'm pulling it up right now. Yeah, October
There's the
4th. Actually, if it's early in the day on the 4th, it works. If it's late in the day, it doesn't because it's
Yom
that's Erev
Kippur
Yom
the next
Kippur.
day, yeah.
Yeah, that's Erev Yom Kippur. The following week, I don't know if there are hearings on the 10th and 11th.
17th and 18th.
17th and 18th are out because they're Shemini Atzeret and Simchat Torah.
And then the next one is November 14th.
Well, October 3rd we could do, and October 4th early in the day we could do. It's
So
just
we
it gets
can do
late on the
October.
4th, it gets dicey because of Yom
Well,
Kippur.
We can do
This is-
October 3rd.
Right. We're going to close. So,
Okay.
Yes, Mr. Matthias.
We're not loading October 3rd, Carla?
What?
Did you check up October 3rd?
This is
Well, this is a decision, never
This is
mind.
a decision.
Never mind,
There's
never mind,
nothing to review.
never mind,
Okay.
never
Yes.
mind.
So this will be very early on in our review session.
Right, never
This is-
mind.
That's great. Anytime on the 3rd is fine, and as I said, early on the 4th, because Yom Kippur begins at sundown on the 4th.
This would be on for decision, so it doesn't matter.
So on for decision for October 3rd. Motion to close?
Chair Perlmutter. Oh, sorry about that.
That's
Vice
okay.
Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Shetta.
Aye.
One second. Sorry, one second on my vote sheet. Oh, I see what it was. It was a typo. Okay. Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Shetta.
Aye.
Commissioner Shabeta.
Aye.
Commissioner Yoon.
Abstain.
Okay, thank you.
Thank you
Sorry.
very much. Have a great day and welcome to the board, new commissioner.
Thank you. Thank you.
Thank you, everybody.
Okay, so this one's
Thank
split.
you. Have a
Okay,
good-
item number 32, 2022, 10 BZ, 55 Prospect Street, Brooklyn.
All right.
Hello.
Think we're Charles Bonello, Benjamin
John
Newton.
Highland. Anyone else, John?
I don't think so. There may be some people listening, but they would only come on if there were specific questions, the architect and my colleague, so.
All right, we'll swear you in, but I think there's only the DOT thing, but raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
I do.
Okay.
So good afternoon. I listened to the review session. This is John Highland. I believe, as we said, we had gotten late yesterday afternoon some additional comments from the
DEP.
Our consultant reviewed them, and it appears that there's some confusion as to what's being asked, that it may not even apply, because they're asking for industrial permits, and this isn't an industrial area. So I believe Tracy has been in further contact with the DEP, and they're going to try to clarify it, and if necessary, they would, we would have a call with our consultant and the DEP to determine exactly what they need, if anything, at this point. The additional items that they're requesting may not be necessary. So based on that, obviously, we would like to resolve this as soon as possible. This is really the only issue, and it would have been resolved earlier, obviously, if we had gotten the DEP response earlier. So.
And that's the only thing that is outstanding?
Yes, to my knowledge, yes. The DOT approval was given on July 19th after the last hearing, based on what we discussed at the hearing. Everything that they had asked for was incorporated, and everything else has been approved. It's just these, these additional comments that the DEP gave, which we were a little surprised about.
Ms. Benke, how quickly can that be resolved?
Unfortunately, I don't know. DEP, they asked for formal requests for, because the applicant gave us some information today. So we made a formal request, and they said they're going to look at it as soon as possible, but they can't give us a promised date. And it is some detailed backup data they'll be looking at. So, but if what they have is not what they want, they are open to a call. But I don't know what their time frame is. They can't tell me right now.
Well, could we put it on the September calendar? I think we should be able to talk to them before then.
Let me ask you a question. By when, what is your timeline of starting the program?
Well,
we're hoping.
They can explain it.
Look, we're starting to enroll families. We've had a lot of interest. Our hope is to open this up by end of October. I just don't know if that's even going to be feasible with further delays in this. So that's our hope.
Are you working parallel in terms of getting other plans and drawings in place and construction? Are you?
I believe so, John. You can comment any further on that, or I think our architect may be on the line as well.
The reason for asking this question is, if this is the only thing that's holding up, how parallel are you working to get other things in place? And you need this to pull the building permit, right?
Right. I believe they've been working. Things have actually heated up recently with the fire department. They're finalizing the approval for that. And then once we get the BSA approval, then we can finalize the DOB approval and the Department of Health approvals. So this, we had hoped that after the last hearing that we would be able to finalize it today. And then, obviously, this other issue has come up. Although I still, I understand what Tracy said, but I don't think this is going to be that complicated. Once the DEP looks at it, and if need be, talks to our consultant.
Okay. Our schedule for September is extremely booked. Is our executive director around?
Yes, I'm
because
here.
even if we close it in September, we will not be able to make a decision on it until October.
Well,
That's the,
if that's what has to be, but at least if we were able to close it in September, then we would have the October decision.
right. Okay,
That could work, Madam Vice Chair.
that could work.
Yeah, there's not much to review, right? We're just waiting for,
Right, there's really nothing else to review except for the DEP to review these, first clarify and then review the additional items that they want. I think they've already been sent them, and some of the, like I said, some of the things that they're asking for probably aren't going to be necessary. So it would really just be the getting the final DEP sign off.
Okay. We'll do our best, and I know our team works very closely with your consultant, so we'll see what happens. Let's go to the public. Any questions from the commissioners? Okay, let's go to the public.
Okay, the case that we're currently, am I still muted? Oh, the case that we're currently discussing is 2022-10BZ, 55 Prospect Street, Brooklyn. This is a special permit for a daycare center. Should you wish to discuss, dial in 646-558-8656. You will enter the webinar ID number as 834-2722-0881. Press the pound sign. At the next prompt, you will press the pound sign. Once you are in the Zoom room, press *9 to raise your hand, *6 to unmute to be able to speak. If you are in the Zoom room already, please raise your Zoom hand.
Okay. So while we're waiting for people to call in, if any, let's try to work with, I'm sorry, that is the best we can do. We cannot close with outstanding secret issues. So, and we need DEP to sign off on air quality and noise, because the comments and notes from that will have to be reflected into the drawings and would be part of the condition.
No, I understand. Yeah, that's why I said if we could, have the September hearing date, maybe we could hopefully close that, get the final approval in October.
Okay, all right.
Vice Chair, this is Charles from Vivi. We're all very grateful for the hard work, diligence and support that we've gotten from this group, as well as all the agencies. Understanding that we're working very hard and very quickly to get open to serve families in the community who are in deep need of childcare. I'm just wondering, is there anything that we can do to help accelerate this? Is there if the DEP comes back and approves this after our discussion, then the process thereafter would be for the BSA to approve it or to vote on it, right? Is there any instance where it's almost like a sealed approval upon the comments from the DEP that could help expedite this?
Unfortunately, the month of August, everything seems to move very slowly with all things on vacation. So as optimistic I am in getting the approvals in place, it become, it would be difficult. That's the reality. And also our hearing, all our calendar dates are, we have today, this is the last hearing of this month. And then the next hearing is in September. Then there's only one hearing in September. And while we are fully booked in September, we do make exceptions in situations like yours to make sure that we can put your case there, because we recognize the time sensitiveness of this, so that we can get this out for October hearing. October decision. And that is the best I can promise. It would not, it's not possible otherwise.
Okay, thank you for.
It's a fair question, and you had to ask. I completely appreciate that, but it's something that we cannot do given our workload and the holiday timing, scheduling with people on vacation. It's going to be difficult.
Okay, thank you very much.
Thank you. Okay, so let's keep a close eye on it, and your consultant and Tracy can hopefully get DEP to a safer place.
So will we hear then if we're on the September calendar?
We are going to put a hold for you on September calendar.
Okay. And what date is that?
It's either the 12th or the 13th.
Okay.
Right, and if not, I think we'll also, let's put a hold also in October.
3rd, October 3rd.
Yes, October 3rd.
Yes, that won't be an issue.
Yeah, that won't.
Yeah, I think we definitely should have something resolved before that. And then.
Well, thank you very much for your consideration. We appreciate it. We know that, as you said, this is a difficult time with the scheduling at the end of the summer, and we appreciate you making this exception.
We'll do our best. And thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.
Okay. Do we want to continue or break or anything?
Does anybody want to take a 5-minute break? Because we have few cases, there'll be public testimony.
Nope.
No,
Okay.
We are marching forward.
There you go. Tried and true. New cases, item number 33, 2021, 55 BZ, 13416 35th Avenue, Queens.
Hello. Elise Fullader. We should have a bunch of people on for this one. We should have Edwin, who's the architect, Clyde from Aeronautical Engineering. See any of those? Do you see any of those people?
I see Clyde Pittman.
Yeah. Oh, Edwin Tang, yeah, and then there should be also a Stephen Bay. Bye.
There was a Mr. Bai, yeah.
Yeah.
Stephen Bai.
Okay. I think that's everyone, unless there's someone else raising their hand who I'm missing or anything, but I don't think so.
Okay. All right, ready?
Mhm.
Please unmute. Mr. Tang, please unmute. Thank you. You're part of the team, right? Okay, everyone who's part of the team, raise your right hands. Do you affirm to tell the truth, the whole truth, and not Mr. Zhao? Are you a part of the team?
Yes.
Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond on the city board member questions?
I do.
Yes.
Elise Fullader from Eric Palatnik PC. Thank you so much for your comments earlier. We're going to go comment by comment, but first, because the most important questions are obviously the FAA approvals. So we will turn to Mr. Pittman from Federal Airways and Aerospace. He's the aerospace engineer to speak on those questions.
Just one, before we start that, Elise, I emailed the commissioners those letters. Is that what you needed? Okay, good. Okay, we got that down, Elise.
All right, no problem. And anything, if you need us to share or show you anything that you might be missing, we're more than happy. But Clyde, take it away.
Well, if anybody would just like to ask a specific question, I'd be glad to answer.
Should we go through or comments?
Yes.
Okay. So I guess, Clyde, I could bring up the comments if you want to answer them question by question.
Okay.
No problem. So first question was, sorry. Drawings, two-story building, parts so there was questions about an FAA approval letter. I don't know if Tony just resolved that, but we had a bunch of letters that were, approved for each of the different points. So I think there was some confusion on if that's how the FAA works and if those are the approval letters we're looking for.
Yeah, the points that were submitted were intended to engulf the whole property so that whatever was built would be built within inside that envelope, and then it would have full FAA approval. And that was the intent of submitting all those points.
So I have a question. So even though you're proposing two buildings connected at the lower floor with the higher massing on 35th and the lower one on Northern Boulevard, technically you're saying you could even have a taller building on Northern Boulevard provided it's within those points of elevation.
That's correct.
Okay. But that's not what you're proposing. You're proposing is what's being shown in the plan,
Yes.
which is a 12 on 35th. Okay. So just out of curiosity, why does FAA do that?
Well, they have limits, as we talk about, there's certain limits that the aircraft have, and there are certain limits that the building height is. So there's a buffer between the aircraft. So what we're trying to do is stay below the approach envelope, which would be a 34-to-1 surface that that goes out 200 feet out beyond the end of the runway, and it continues up and out at a 34-to-1. So if we stay below that surface, all okay.
So FAA is not reviewing the building height. It's just looking at the site and placing it under all the analysis and saying, if this is your building site, these are the maximum points on this site that can height can be achieved.
Right.
Okay, got it.
And if
But
there's sorry.
Yeah, the 6 story is not dictated by the FAA, right?
The 6 stories is dictated by the customer wants.
Okay.
So if the applicant, in other words, Commissioner Shetta, and correct me if I'm wrong, Mr. Pittman, if the applicant wants to switch the building around and wants to have the 12-story building on the Northern Boulevard, the 12-story building has to stay within that per maximum building height that the FAA has prescribed for that point, which means,
yes,
right?
Yes.
Which, if it happened to be lower, it would have to be lower than what you have on 35th.
That's correct. Yes.
Yeah, Mr. Pittman, just to clarify, I didn't question why you're submitting the forms. What I questioned is why the elevations on the drawings are as high as 222, while I did look at the forms that you initially submitted to the FAA, and I looked at the site elevation, and then I added the height of the structure. And that gave me the top of building elevation in NAVD 88. And I see when you add these two numbers, it's every time you add them, it's giving you 213. My understanding to this is FAA is limiting the top of building elevation to 213. Is that accurate?
I believe so. As long as it stays below that 34-to-1, then we're good. That's the key.
Okay. Is there an issue to eliminate the elevations? I'm not sure if you saw that drawing that I shared, but on one of the drawings, let me just bring this quickly. Yeah, here. Number one, it's confusing to say approved height. I believe it should say approved top of building elevations. Is that an accurate representation?
I'm not. Could you repeat that question? I didn't quite understand.
Sure. It says here on the drawing approved height. I perceive this as the 213 to 214 and so on. These are the heights of the building. My understanding to these numbers, based on the excellent study you prepared, is that these are not heights, these are top of building elevation. Did I understand it right?
I'm understanding it right.
I think we are looking into, I think we are getting into various agencies using different vernacular for kind of saying the same thing.
Yeah, that's as high as you can go.
Elevation or height?
AMSL.
Let me repeat what I said. Is the 240 is the height of the structure from the site elevation to the top of the structure, or this is just the site elevation plus the height of the structure?
The height to stay below.
That is the elevation in NAVD 88. That's why we put the NAVD 88 right after that title of the column, because it's denoting height above sea level.
That's my understanding. So this is elevation, not a height, right?
Correct.
So please, here, make it approved top of building elevation. And then NAVD 88 is telling us what datum is being used to reference that elevation to.
Yes, okay, we can do that.
Thank you.
Okay, no problem. And then, so are you clear on, there was another part, now that we have Edwin here, where you shared where this reference point you were talking about. We can share that plan if you're not clear still on that, and Edwin can speak to that, because I think that
sure.
So Edwin, or you could share. There you go. Can you see that, Edwin?
Mr. Pittman, in your study, I did read, and I'm reading from page, give me 1 second, let me grab that. Yeah, this is page 11 of the PDF. And it says conical surface. And under that, it says the conical surface is an imaginary inclined surface extending upward and outward from the edge of the horizontal surface. And then it proceeds to indicate that surface starts at the end of the 150 foot above the airport, the horizontal one. So if my point is, if it starts at the end of the 150, the way it's shown on the drawings is, you see that dash red line, it goes to the elevation, the reference elevation point. This doesn't start at the end of the 150 horizontal surface. In order to make it consistent with what the study says, it should start here at this point. Is that correct?
There's two horizontal surfaces that we're talking about here. One of them is in your zoning ordinance. That starts at the airport reference point and goes out 10,000 feet? Goes
Yes.
out 10,000 feet. And at that point, the conical surface starts also at the airport reference point for your zoning ordinance. And that was the way it was with the FAA back in the 40s and 50s. The FAA Part 77 surfaces, as you say, it starts at the end of each runway, 200 feet off the end of the runway, and we swing an arc of 10,000 feet. That would be 150 feet above the airport reference point elevation. And then the conical surface starts at the end of the horizontal surface where it terminates. It starts at 150 feet, and then it proceeds outward an additional 4,000 feet for the
Yes.
FAA. And in this case, it's 15,000 feet for your zoning ordinance.
So it's the blue, not the red. Am I correct? The blue starts at the end of the 150 foot above the airport.
Yes.
But the red starts at the reference point. So it's the blue, right?
If I'm reading this correctly, that one line is 150 feet above the airport reference point.
That one.
Right. But it goes out starting at 10,000 feet from the end of the runway.
Which is here. Yeah.
Yeah, but it wasn't, it starts at the end of the runway, and I can't tell where the runway begins or ends from this drawing.
You want me to share your drawing? The architecture?
Yeah, let me share mine, because I'm sure we're going by the definition of what a conical surface is, and perhaps that would help clarify. So I've pasted the definition onto this sheet. So we're talking about the section diagram here about where the conical surface 20-to-1 slope should begin. And when I look at 6120, the definition of conical surface, it says it has to extend outward and upward from the periphery of the horizontal surface, which rises at a slope. This is sub item A, measured in an imaginary vertical plane passing through the airport reference point. So it's a line that has to pass through the airport reference point, which is what we drew in the red. And then it goes up 1 foot for every 20 feet in horizontal. And
But
then it's
where
also,
does it start?
so in order to pass through the airport reference point, that means it has to start at the airport reference point, right? That's our understanding.
Which is the 20,
Yes,
the 18 foot, 18.911.
18.911 NABD, yes. And that we literally
that
followed
is-
the definition in zoning.
Right. And that is the
Mr. Pittman?
50,000 conical surface.
Yes. Yes.
I'm learning.
All right. Interesting. Always we are
I'm asking Mr. Pittman because there is a statement in the study that says it starts at the end of the horizontal surface. That's what it says. So my understanding to that statement is it starts here. I'm not sure if the architect did look at
I
it.
don't have a document in front of me.
If you take your screen, I can share the study.
Let's stick with one screen. I think we have the same information on both the screens. So let's just stick with this. So. All right. So what, Mr. Tang or Mr. Pittman, do you want to answer to that question?
Let me just read this. Look back at page 11 in the document, see what it
Yes,
says.
yes.
Because the rising incline slope starts at the edge of the horizontal.
Second line per paragraph.
Right, but at 20 to 1, start at the same 10,000 feet. Stand by, please.
Sure.
It's 200 feet.
I could cover the one easy comment. We'll get you a new survey that's more clear.
Thank you.
Thank you.
That's the one easy comment I can do in the meantime. And everything else.
In a sense, the surface starts at the peripheral of the horizontal surface and goes out, and essentially that just makes it easier to understand. But I suppose if we look at the actual ordinance that you're dealing with, it does pass through the center of the airport reference point.
So in other words, Mr. Pittman, what you have stated in the special aeronautical study and what the diagram is showing is consistent.
I believe so.
If a line passes through 2 points, it should be one line. How come we have 2 surfaces and they are 2 like different lines in the meantime? One of the statements, the one on the drawings and the one in the study, is not consistent with each other. You know what? Let's move forward. I'm fine. If you don't want to fix it, don't fix it.
No, it's not the issue of fixing it. It's just making sure we have the information consistent. And honestly speaking, I think the expertise lies with Mr. Pittman and FAA here. And the architect is probably taking guidance not only from the zoning, but also from Mr. Pittman in terms of making sure diagrammatically it is representing it accurately.
Yes, we were in coordination.
Okay. So what I would suggest, in the interest of time, we have a lot of people who wants to speak in. Just go back to the documents that you have submitted and make sure they're consistent.
No problem. And maybe offline, everybody can think about it a little bit easier.
Yeah.
Thank you.
No problem. So thank you so much. So the next group of comments, Stephen and Lynn are here to help answer. The status of construction came up, and relationship, status of construction, and then the letters we received. So Stephen, would you like to address the status of current status of construction and the letters we received from the BSA in the past few weeks?
Actually, you know, I'm gonna like speaking about this. So, okay. Yeah. So my name is Lin, and I'm like one of the member of the ownership entity and from the owner side. So the status of construction, so like right now, so we are doing the foundation and the structure, and as you know, as of right approval and of the height, and so after that we get the BSA the approval and for a height waiver, and we will file the amendment to the DOB and to increase the height of the building, and which allow by the FAA, and so that is the status. And also, so like regarding about the letter we received from the BSA and regarding about the neighbor complaint, and you know, just be honest, and we have not received any formal complaint from the neighbor, and we have, you know, like the ownership information and on like our in front of our construction site. You know, it's really like clear and big, and you know, we also have project manager there, and we have not received any formal complaint and from the neighbor. And also like right now there's no any like safety violations, outstanding safety violations related to this neighbor complaint. And you know, and the DOB inspector came to the site and multiple times, almost like, you know, once every other week. And you know, we have no violation related to directly related to this complaint. So if neighbors, you know, like have more concerns, they can always come to us, and our information just right in front of our job site. And yeah. So.
Thank you so much.
Yeah, if anyone have more questions about this, you know, more than happy to answer. So
thank you.
I just want to go back. I think somewhere in my note I have that there are 3 ECB violations, which is regarding construction safety enforcement. Were those resolved?
Yeah, it's already resolved. Like right now, there's only one open violations in the DOB website that's related to you know, the existing building violations. That's nothing to do with the construction. And so, you know, once we take care of this, the existing building is no longer there, but we didn't like, we usually like correct them, you know, after the new building is finished. So yeah, then like right now, currently, if you go to the DOB website, there's only one outstanding violations, but that's related to the, you know, previous existing building by the previous owner. So it's not like a safety violations outstanding. So
I see Ms. Benke's hands up.
Yes, I just wanted to speak briefly about the type 2 application. This type of application is considered a type 2 if several prerequisites are passed. So the noise analysis passed the initial screen, so there's nothing further on that. But I just wanted to confirm if there's any new in-ground disturbance, we usually ask for a hazmat and historic resource assessment. However, the applicant holds that all excavation work has been completed, so there's no new in-ground disturbance. And I just want to ensure that's okay with the board. That no further, do we find that acceptable that no further hazmat or historic assessment is
Well,
needed?
I think not, because what is being built is an as-of-right building. And so I'm assuming all the in-ground disturbance, if anything has happened, has been as part of an as-of-right development. And therefore, I would say no.
Okay. Thank you.
Is that okay with you and Council Member, I'm sorry, General Counsel Vine?
Yeah, that's fine.
Thank you.
Okay, thank you. All right. Do we have any additional questions or comments from the commissioners to the applicant? If not, we will go to the public.
Let me,
yes.
Can we allow the interpreter in? He's from Legal World.
Yes. Let's start with that.
Please unmute. Can you unmute, Mr. Chow?
I just did. Hi, everyone.
Okay. Can you state your name for the record?
King Chow, K-I-N-G-C-H-O-W.
Okay. So what I'm going to do is read the call-in information, and I'll read it line by line. And if you can repeat that after me, I know you speak both Mandarin and Cantonese. Unfortunately, I'm not aware of what the neighbor speaks, so that's why I asked for a dual person. Okay.
Okay, so you want me to translate or interpret line by line?
Yeah, so you actually have a copy of the calendar, but just if you can repeat after me what the call-in is, and I'll go very slowly. And then once the neighbors come in, if you can translate for them. And any questions that the commissioners ask, translate back and forth. Okay, is that fine, Chase?
Miss Matthews, can I make a suggestion in this case? Since it's a written text already, maybe you can read the direction that they have to follow.
I don't know if you can see it. I don't know if you can see. Can you see
but
the screen?
when you put up the screen, yes,
Yeah.
when you put up the screen, you can read the whole thing in English, and then maybe Mr. Chow, you can read this in Mandarin and in Chinese and Cantonese.
Okay.
All right, thank you. That's better. Okay.
Thank you.
So the case we are discussing is calendar number 2021-55BZ, 134 16 35th Avenue, Queens. If you wish to discuss, dial 646-558-8656. Enter webinar ID number 834-2722-0881. You will press the pound sign. At the next prompt, you will press the pound sign. Once you're in the room, press *9 to raise your hand, *6 to unmute to speak. That's on the phone. If you're in the Zoom room already, raise your Zoom hand. Okay, Mr. Chow.
OK， 现在首先是国语的翻译。现在我们是第33号，我们的账户号是2021 55 BC 是134-1635大道，在皇后区的。这个是一个特别的批准，要去允许新盖的一个建筑物是超过在 ZR6121 还有 C2R6 的那个分区这个条例里边的。所以我们现在呢，如果你是想发问问题呢，请你打646-558-8656，在这一个 Zoom 的一个号是834-2722-0881，然后按井字，然后如果你想，just give me 1 second。OK， 所以你要按星9号去举手，然后按星6号去静音。如果你已经在这个网上的视频的会议呢，你可以按一个举手的。So this is I'm gonna do it in Cantonese。呢個係項目33號編號係2021 55 BC， 係有關136 1635大道皇后區嘅特殊批准，要批准一個新嘅建築物係超過ZR6121 C22R6 嘅分區劃裏邊嘅高度嘅。如果你係想參與呢一個討論嘅話咧，請你打646-558-8656，跟住咧呢個會議嘅號咧係834-2722-0881，按井字。 如果你想舉手嘅話咧，請你按星9；如果想靜音嘅話咧，請你按星6。如果你已經喺呢個視頻嘅會議上邊咧，有一個掣咧，你係可以舉手嘅。I'm done.
Okay.
Thank you.
I don't see anyone. There's some people. So far, I don't see the names of Mr. Chang and I don't remember the other person's name. I'm sorry. It's okay if they're not. How long do you want to wait?
Let's give a little bit of time than usual.
Because I know the YouTube is a little slow.
Yes. Okay. 2 minutes have gone by.
Not yet. Okay, I don't see anyone else adding into the room.
Okay.
Do people ask for interpreters? I
thought it was nice.
I
said I thought it was nice.
No, you have to provide an interpreter. So.
If the interpreter would just interpret the following. If there is anybody in the Zoom room who would like to speak on this application, please raise your hand.
大家好，如果你现在已经在这个 Zoom 的会议上呢，你想发言的话，请你按一个举手的。大家好，如果你喺呢個 Zoom 嘅會議入邊咧，你想發言嘅話咧，就請你按呢個舉手嘅一個掣。
Okay, let's just give another 1 minute.
Okay. Okay. Mr. Chow, could you also interpret? If anyone who wishes to comment may also submit comments to the board in writing.
Anyone to give the email address?
Yeah. The email address is submit@bsa.nyc.gov.
Thank you.
Submit@bsa.nyc.gov. Anyone who wishes to comment may also submit comments to the board at this email.
係，如果大家咧想去有評論嘅話咧，你可以書面上提交， 你可以去電郵電郵地址咧係 submit 就submit@bsa.nyc.gov。 OK， 如果大家你现在有希望想发言的话呢，做评语的话呢，你可以用电邮去提交，那个电邮号呢是 submit@bsa.nyc.gov submit@b as in boy sa.nyc.gov。
Okay, great.
Thank you, Mr. Chow.
You're welcome.
Okay, so we didn't hear anybody from anybody, but as I think it's been stated during the hearing, you know, what is before us is very specific, and BSA is not approving the building permit. It is for DOB. And DOB has approved an as-of-right development as of now, and should BSA approve this, the applicant will revise the DOB plans to facilitate the proposed development, and DOB will be responsible for ensuring all development on the site complies with all the codes and regulations, and will be overseeing the for monitoring the construction for consistency with all the rules and regulations. The applicant also stated, as applicant's representative stated, that they are their phone number is there, and any questions, any issues that comes up, please directly reach out to the owner and also to DOB. Okay.
Do you mind? Oh, go ahead, Chase. I was just gonna.
Hi, Vice Chair. I'd just like to keep seeker open to look into the question of hazmat and LPC if that's possible. With respect to the in-ground disturbance question.
Okay, is it because of its proximity to? Okay, all right. Does that mean that we cannot close?
Yeah, I'd request that the board do not close today so we can look into this applicability of seeker regulations under type 2 prerequisites.
Okay, all right. I'm sorry. I'm being advised by my general counsel that we cannot close. So when can we schedule this for a hearing? Can we schedule it for September?
That would be fine with me.
September, Chase, is that okay?
Yeah, that would be fine with me. If it would just be a small matter to add, if that's okay with the board.
There isn't any, only change would be that table number, the change to the table heading. And should there be any correction that needs to be made with the analysis that Mr. Pittman made and the architect, that would be reflected. But as Mr. Pittman is saying, the drawing is consistent with what the analysis states. And I think those were our primary comments. Okay. So we will have to keep it open, and we will hold a hearing in September, and the submission date for September is August 24th, right?
Yep. I know that one.
Okay. Okay. Thank you. Thank you for your participation. And Mr. Pittman, it's always good to see you. We always learn something.
Thank you.
Mr. Zhao has, I'm sorry if I don't pronounce your name. Is Zhao has a?
Yeah. Yes. Yeah, I really appreciate that everybody take the time and consider our applications. So based on my understanding here, so the only things remaining is about like the type 2 applications, and so you guys need to take another look. So my question is like, so is there anything that we can do, and you know, I needed to provide was, you know, for you guys to you know, like complete the review, you know, like type 2 applications, you know, we're more than happy to submit additional information, let's say from our engineers, and saying there's no further ground disturbance, like of the construction ongoing. So, I just want to see if anything we can do and to help you guys, like to resolve this matter. So.
Well, I will reach out to Ms. Fullader directly if
no
there's
problem.
anything required. Thank you so much.
And Mr. Zhao will be in contact, so we'll let you know how the whole thing, the submission.
Okay. Yeah, just want to
Thank you
make
so
sure.
much.
So, if anything we can provide, we're definitely more than happy to provide, help you guys resolve this. So, yeah.
Thank you.
Thank you so much for everyone. So.
Thank you all for participating.
That's it.
Yes, next item.
Okay, thank you. Thank you, Mr. Chair. You can go. Thank you. Thank you so much. I'm sorry. I was told two people wanted to come on. Okay. Item number 34, 2021-61 BZ, Eric Palatnik, 4080 Ocean Avenue, Brooklyn.
Hi, Elise Fullader. I should have an Anna on.
So it's on the.
Anna Kornikova.
There
I feel
she
bad
is.
because I'm probably screwing up everybody's name.
Sopretic. I thought that's not Kornikova, but okay.
I'm here. Can you hear me?
Yes. Thank you.
Great.
Can you join as panelist?
Excuse me?
Can you join as panelist with the video?
Does it let you do
I
the
think
video?
so. It depends
Okay.
my laptop.
Yeah, I see you. Very good.
Okay, raise your right hand, both of you. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to the board member questions?
I do.
Okay.
Elise Fullader from Eric Palatnik PC. We're going to go through your comments. I'm going to share the plans if that's okay, so we can ask questions as we go through the comments to make sure we fully understand what you've asked. So let me get out of the FAA one. Sorry. Here we are. Share. I guess we can get a little bit closer up. Can everyone see that, or is it really small on everyone's screen? No, maybe. Hopefully. If I need to get closer, you'll let me know, but we'll go through the comments. So first is on the zoning analysis form, it did say 40 feet, but that was just for the proposed. It is supposed to be a 30-foot, not 40-foot depth, and we'll correct that typo. So that's the first comments, and we'll correct it throughout the statement of facts and anywhere else where it was picked up. We heard the board's analysis about the side yard, and we would agree with the board's analysis about the side yard. I guess if Anna wants to speak on that at all, she can, but we'll correct it through the plans, the statement, and the zoning analysis form. Is there anything you want to add, Anna, on that one? Or?
No. Just I definitely agree.
State your name for the record before you speak.
Oh, okay.
So just so I understand, the zoning analysis will be corrected for the as of right. The proposed, you are proposing a new side yard.
We are not proposing like a new side yard. If you take a look like the existing plan, they have only one side yard, and the existing building is kind of like wider. The proposed building, just we counted from the like first floor. That's why I think I just included this side yard, but I totally agree, just probably we shouldn't do it.
Is there a plan page I should go to that clarifies that?
Yeah, I'm looking at BSA 004, and so the cellar, for example, the cellar width is 24.5 feet. And the ground floor, the first floor, would be 20 foot 5 inches.
Yes, it's more.
So that's why I thought you're basically shaving that portion of the building on the north side by making the building plate thinner, narrower from 24 to 20, and therefore increasing, creating a side yard.
That's right.
You are?
Yes, but maybe we need to rename it and just call it proposed side yard.
Yes, yes.
Okay.
So yes, I think Ms. Fuller, I don't know if you have done many of these 73-622s. I think some of the information got lost because of the diagram, and I guess we are not used to seeing it in this format. So maybe a little bit of the formatting of the diagrams can clarify a lot of the questions that we have. So we can send a sample over if you don't have one, since I don't know if you have done many of these, and maybe that can help.
I think it would be helpful. Oh, sorry.
And also, sorry, I was just going to say, because this is in a flood zone, sometimes the rules on that got a little changed over time. So if there's a more up-to-date sample that is in a flood zone, I think that would really help clarify.
Okay. All right. Yeah, and that's why I'm not very clear if that cellar skylight is a permitted obstruction, and would that be permitted to remain? That was the other part of the side yard thing. And therefore, would this count as a side yard?
Okay, I see.
And that one we'll have to get back to you in writing because we have to look deeper into that question. Yeah. So appreciate the comment. Okay, and then let's go. And then for dimensions throughout the plan, feet versus inches and decimals, we heard those comments, and we will look deeper into that and make sure that all the dimensions are consistent throughout the plan and everything is dimensioned. We heard that we need to carry the dimensions a lot with from onto the floor plans, but when we see the sample, maybe that will help clarify.
As you know, as part of the front yard, we want to look at not just the front yard depth at the ground level, but also how it's being carried vertically. So same thing with the rear yard and side yard. We want to make sure we want to look at the depth and the width of front yard and side yards, not just on the ground floor, but vertically all the way up to the proposed built height. So that's why we need to have the dimensions indicated on the second floor and also in the attic floor.
And to go into that, we wanted a little bit of clarification about the comment about moving the floor back, so to push back the front yard and have less of a rear. If you could clarify that for us a little.
Sure. So that goes back to the retention of the existing exterior wall. And when I looked at the drawings, and I forget which drawing it is,
maybe this one?
Maybe. So if you look at it, which has the addition at the bottom of the total of the walls that are counted, yes, BSA 005. In that, I think neither the existing wall to remain nor the existing wall to remove accounts for the 19-foot and 15-foot 7 inches inch wall that is being removed from the north side of the building. And when you factor that into the total, it would reduce the total amount of walls remaining from 65% as shown to less than 50%. So
do you see that?
Yes, we can add a section which will have all information, and just you will see the height of this wall. Maybe it can be helpful to understand why we count this existing wall which we're going to remove.
The northern wall you're not going to remove?
Which we're going to remove. I mean about
here?
No, this.
Or
No.
Let's look at the first floor. Cellar doesn't matter. It's the first floor.
Yes. I mean the first floor, the existing front exterior wall. I mean this one. The gray one is the wall which we're going to leave.
Mm-hmm.
Yes.
Okay. I'm talking about the wall along the northern lot line.
Another,
by the kitchen, where the
Oh.
kitchen and that wall is going to be a new wall, right? You're removing the existing north wall.
no, we're going to leave this wall. It's gray, and that's why we count it. We include this wall.
Okay. And the reason I'm asking that question is because when I look at existing plan, BSA drawing 016, in that the existing first floor shows the bump out on the north lot line on both sides. There's a bump out of the bedroom and the bump out of the living room. So I'm confused. If that bump out is remaining, then that's not reflected in the proposed. In the proposed, the bump out is being eliminated. It's the wall that is abutting the bathroom and the kitchen. That wall is being extended in the front and in the back.
We need to take a look at.
Yeah,
Okay.
so and that's why we need the dimensions on the existing and the proposed, and otherwise it's very difficult to go back and forth. And I'm just going eyeballing it by what is being shown, and in that I don't see the bump out on the first floor.
Okay, okay.
As shown in the existing.
I see what you're saying. Okay.
Okay. So if you're going to remove that bump out along on the living room side and the bedroom side, that means that wall is cannot be counted under the existing walls to remain, right? So the new wall, so the existing wall to remain, total existing wall to remain will reduce first of all, the total existing wall will be higher, but the existing wall to remain will be much lower. So that would make the difference.
In all calculations.
And that would make the difference less than, I think, 50%. Based on a very quick back of the envelope analysis that I did, I think it will be less than 50%. So you need to go back and look at that. And if it is less than 50%, to make it 50%, my suggestion was that the wall, if you go back to drawing number 005, where you're proposing to eliminate that 13-foot 6-inch wall along the southern front, you know, where it's a dotted line on the first floor. Do you see it on the first floor?
Yes.
Next to the stair.
Okay, I see. Yeah.
Okay. So if you retain that or a portion of it even.
Okay, we'll definitely take a look.
Right. If you retain it or a portion of it, I think you'll be able to achieve 50%.
Okay.
And what I meant by that is that in no way would affect your second floor. The second floor can still overhang over that little bit of a carve out that you would do on the existing. Any which way, just keeping a portion of that wall, I think you will achieve 50, and then how you handle second floor, that's up to you. But if you want to retain the existing second floor, I don't think structurally it will make that much of an impact. You can create a little bit of an overhang.
Okay. I think we should be fine.
Am I?
You get it, right?
Yes.
Yeah, she's good.
Okay, so just do the analysis, first of all, and find out how much you need to make it 50.
Yeah, we will do it.
Okay. All right.
So I'm sorry, I got so caught up. Did we answer the question about the front yard, whether it should be moved?
Oh, not yet.
Not yet. So there was talking about neighborhood character.
Right. So in this one, the building is moving into the front yard, and so is the second floor. So the first floor is extending into the front yard. The second floor is also carrying the same perimeter wall of the first floor onto the second floor. And then there is a balcony that is proposed. So my comment on the balcony is I do not think it complies with zoning resolution section 23-131.
But it's above, to be accurate, it's 7 feet 8 inches above curb cut. We should be fine.
I don't think that's how it reads. It says if the depth of the front yard is greater than 12 feet, balconies may project 6 feet into such front yard, provided that in an R1, R2, R3 district, the aggregate width of such balconies does not exceed 50% of the width at that level of the plane surface of the building wall from which they project. You will need to do the calculation and make sure you meet that requirement.
Okay.
So if we do comply, then can we keep this as is, or was there still a neighborhood character?
It is still a neighborhood concern to me because this particular block front has a very uniform, first of all of them maintain quite a deep front yard. You may want to do a front yard study if you want to convince me otherwise.
Okay.
But I'm okay with extending the front first floor, but my question was more with the second floor. And go ahead.
I was going to ask, so we could keep it, but you're suggesting to push it back, kind of.
Push the second floor back. And if that means you have to push it into the rear yard, that's okay. But the front facade treatment needs to be more respectful of the built context.
Okay.
Because, yeah, okay, great. And we'll talk to the client about doing that.
Yeah,
So thank you very much. And then another big set of comments was about flood compliance. We heard your note about being in compliance with Appendix G, but wanted to ask maybe about a little bit clarification about Commissioner Shetta's comment about the vents.
Yeah, it's the vent. Just at like next to the vent, say design and review by others. That's all.
Okay, thank you. And then once all the dimensions are confirmed, we will fix them throughout everything.
Yes, and all
I
the
noticed.
right, and all the documents.
I think that covered all of your questions unless I'm missing some.
No, just I
no.
think we forgot about Skylights.
I think she mentioned it and we said we have to look into that.
Oh, yes, that's right. But just I have a question. If
Oh,
these
yeah.
Skylights are above FICE, can it be issue? Or because I didn't find any information about Skylights in Appendix G.
And I think this is where appendix, we are not going to opine on, this is an existing built condition, right? You have an
Yes.
existing. So that's why I would rather have a note there that says it's for DOB to determine and confirm that it's consistent.
Okay.
If it's a pre-existing condition and DOB allows it, applying whatever elements of Appendix G, that's for DOB to make that determination. I'm not, I don't think the board should weigh in on that.
Okay, got it.
The only thing is that put a note in the cellar that says it is not to be used for any habitable purposes.
We have it.
Right, you have that note?
Yeah.
Okay. Just everywhere that should be there very clearly. Yeah, I see that in drawing 006. Yes. Okay.
So we can put it in more places if you need.
Yeah, just to be consistent, you can, yeah.
Did
All
you
right,
respond to the comment with the floor area on the zoning analysis form? I apologize if I missed it.
Oh, no, you didn't miss it. I missed it. So thank you for pointing it out. So
Thank you.
There's also typos or something?
well,
Is it
that
typo
we
or
have
a
to fix.
deduction?
Yeah, we have to fix dimensions everywhere, Tony. So all of that will be changed.
Yeah, but also in the statement of facts, so, yeah.
Everywhere, everything.
So it's a typo, right?
We believe so, but do you want to, can you repeat the question one more time and then maybe Anna can help?
There are two numbers for the floor area. One of them says residential floor area, and it mentions
One
207.
says, oh, okay.
Here?
Yeah.
Because we deduct.
Okay, that's what I wanted to understand. So
okay.
there is no issue then. Thank you.
Okay.
Okay, any other questions that I've missed? Maybe?
No. Any questions from the commissioners?
No, thank you.
Let's go to the public.
Vice Chair, Chief Daly's
Yes.
hands up, I guess.
Yes, Chief Daly, thank you.
Chief Daly? Well, you gotta go to the public first before you talk to Chief Daly.
Oh, is it? I thought.
I gotta call it first. I gotta call it first. then.
Oh, yes.
Yeah.
Yes, thank you.
Item number 34, 2021-61BZ, 4080 Ocean Avenue, Brooklyn. This is a special permit of an enlargement of a single-family home. Should you wish to discuss, please dial in 646-558-8656. Enter webinar ID number 834-2722-0881. Press the pound sign. At the next prompt, you will press the pound sign only. Once you are in the room, press *9 to raise your hand, *6 to unmute to speak if you're on the phone. If you're in the Zoom room already, please raise your Zoom hand, and that is the little hand at the bottom of your screen. Okay. Wait for speakers, and then Mr. Daly, Chief Daly, Chief Inspector Daly.
Probably misunderstood. Maybe he was like raising his hands to us. I believe he's talking to somebody right now.
Oh,
So I wasn't sure.
Okay, it's okay. Safe than sorry. I'm gonna miss somebody that doesn't. Okay. Anybody else?
Okay. I don't think we are going to do it.
Okay.
So while we're waiting for the public, how long will it take for you to make these corrections?
Anna, do you want to speak? Oh.
No, I just
Oh,
agree
you want
with
me to
you. No,
Okay.
go ahead.
I'm
sorry.
assuming she needs at least a month. Am I correct, Anna?
Yes.
Okay. So, and I know you're booked anyway for September, so.
Yeah, it will have to be in October. I'm not sure the first week of October. First hearing is possible, maybe the second hearing.
No problem.
But we will get back to you.
Totally understand. Thank you.
Okay, so you have to revise the plans. So there's a lot you have to do. Who is the project manager on this one?
It's a Darrow case, but we'll cover it, Jill and I. We got it.
Okay, so please share a sample of.
We'll give them a sample.
Especially the one that's in a flood zone.
Yeah, thank you.
Okay.
Thank you. All right. Thank you very much. So second hearing in the month of October.
Thank you so much. Bye.
Thank you.
Okay, item number 35, 2021-69BZ, 24010 Merritt Boulevard, Queens.
We should have a lot of people on this one. We should have Demi from Stonefield. See her. We should have Tom Whitney, the architect. There should be a Cynthia, a Joseph.
There's an Alexis Joseph, Thomas Whitney, Cynthia Rich, and Demi Process.
Yeah.
Process, I don't know.
You have to ask her how to pronounce her name.
Okay, those four are yours.
Yeah. Don't see them here yet.
Mr. Goldstein, are you joining?
He's just waiting patiently.
No, I just run back in and they put me in as a panelist.
Oh, gosh. You're not for this case, Mr. Goldstein.
We can go back to my days as opposition work if you want.
No.
Panelist Stu Klein.
Let's not go there.
I was charging my computer.
So is someone letting Alexis, Joseph, Cynthia Rich, and is Joseph Cosenza also part of the team?
Yeah, maybe that was the Joseph. I'm not sure who Alexis is.
Said Alexis Joseph.
Oh.
Says Alexis Joseph.
So Alexis,
But
Are you
I
part of the
only see
team?
Demi on my view. Oh, there's Joseph. The Joseph that just came on is the right Joseph.
Oh, okay, so maybe Alexis is for something else.
Yeah, I'm not sure.
so it's just Thomas Whitney and Cynthia Rich from your group?
Yeah.
Joseph Consenza and Demi
Demi Process.
Process. Okay, these are all your team members?
Yeah, but Tom is really important and I don't see him. Oh, I see him now. Okay.
Yeah. Okay, everyone, could you, Mr. Whitney, could you unmute and join a panelist if you can, so we can see you?
I'm right here.
There you go. Great. All righty, we're ready to rock and roll here. Raise your right hand. Okay, to your, actually right hand. To you, to tell the truth, the whole truth, nothing but the truth in your testimony before this board and to respond honestly to board member questions.
I do.
I do.
Okay.
Elise Fullader from Eric Polanic PC. We have Demi here from Stonefield, our traffic engineer. Tom, our architect, Joseph and Cynthia, I believe, are here, right? And they're from the ownership, and we'll go question by question. So here we go. So firstly, we got the DOT comments yesterday, and we are adjusting the queue to do 22 feet per car, as you mentioned in the comments. And so that those 3 extra spaces after the queue was just trying to state that after the queue, there's even additional room, so it won't flow into the street. But that will be revised because based on however our queue is revised in response to the DOT comment.
So would you still be able to have 17 reservoir spaces with the revised queue depth?
Tom, would you like to answer that based on your analysis yesterday?
Sure. So we took a quick look yesterday. Like I said, we've got the comments yesterday. When we go to, right now we queued at 20 feet, which is a standard Starbucks uses, a little bigger than a normal parking spot. 22 feet would put our queue at 15 within the queue, but still 17 before the curb. The additional spaces after the pickup window also help when people, let's say, want to put their wallet back in their pocket or whatever, they can pull forward and allow someone to start their service. Gives that little extra flexibility at the end of the queue, so they don't have to multitask, after the queue. So that's why there's a little space there. It worked out well to do that, so to try to help keep things moving on the site.
So explain where the 3 additional spaces would be provided after one has gone past the pickup window.
Okay, let me.
It might not be relevant anymore. I'm saying after all of this. I think
well, you're still, I think, unless I misunderstood, if the total queuing space reduces to 50, you're saying you still would have 17, counting those 3 spaces beyond the queuing area.
No, before they were closer together and we had beyond the 17, we could fit, like if someone pulled in, there was extra space for those people, but now it's spread out.
Yeah, we were just indicating that, that's where the 17th reservoir space is, there's still some space between that space and the driveway. So, technically you can fit a couple more vehicles there in that scenario that all 17 were, filled up. But yeah, I think that'll change now once the queuing.
Okay, because I was getting worried as to where they would be queuing up and how that would affect the in and out flow from Merrick Boulevard. That's why I was asking the question. Okay. So you're saying
they're not designated queuing spaces. We were just saying there's technically extra space on site.
Okay.
We just didn't want anyone to be concerned because it comes up a lot that Starbucks will overflow into a major road. So we're just trying to show that there won't be that overflow.
Right. I think the concern that and I think DOT is definitely looking into it, is that once you reduce it, it becomes 15. And since primarily this is a drive-through facility, you're going to have more vehicles coming in, driving through it rather than vehicles parking. So it's not going to be like somebody says, oh, if my drive-through is very heavily booked, I'm going to park in the parking lot and then I'm going to join the queue. That's not going to happen. The bottom line is you don't want the drive-through to overflow into the oncoming eastbound traffic on Merrick, right? That's really what you have to prove. And by reducing it to 50 and with such a high utilization of a drive-through, your analysis needs to be convincing where it would not result in vehicles backing into eastbound traffic movement of Merrick.
Could I just add something? Because I actually have had an experience going through a drive-through like this in an area that was in suburbs. And it turns out because they do have that proposed walk-up window and you can do mobile order, there are still quite a few people who opt to park in the parking lot and pick up their drinks at the window. So it's not like it's solely drive-through. Not that I'm trying to make the applicant's case for them. I'm just trying to provide a little more sort of detail to actually what goes on at these Starbucks drive-throughs. So you have a combination of people. You have people who wait in queue and people who just put the order in on the mobile order and just run to the window, pick it up and hop in their car and leave.
Yeah.
Okay.
You're exactly right. That's the purpose of the pick of the window, because people, especially during the pandemic, really started utilizing the apps, and people who are familiar with apps are like, I know I drive through there at 7:15. I'm going to have it ready. And I'd rather zip into a parking lot than get on a 15-car queue. It also allows pedestrians in the neighborhood to utilize the facility and walk up and get a coffee as well. So
you may want to then revise a little bit of what you have in your statement and beef that up to make that argument, and also make it consistent in your engineering report. And a lot of that is being driven by what DOT is assuming and asking you to analyze. So
understood. And I think that goes to the next question you have about passerby traffic. DOT asked us to assume a certain amount, even if we have experienced something different. So I have Demi here to explain that, and I can update my statement of facts accordingly.
Sure, yeah. I'm just gonna provide some clarity on that pass-by confusion that came up. I guess in our report, we said that the majority of traffic we're expecting to be pass-by traffic, but then we only took a 50% credit. And that's just because 50% is the maximum allowable pass-by credit we can take in New York City per seeker standards. So, and that's for any use in New York City. But, per other industry standard methodologies, such as ITE, the Institute of Transportation Engineers, ITE's Trip Generation Manual 11th edition actually projects for coffee shops with drive-through uses up to 90% of pass-by during that morning peak hour. So in our report, we were just indicating that, we did apply the conservative 50% per seeker standards, but we are anticipating here that the large majority of traffic is going to be pass-by traffic.
do you have any such facilities that you can kind of refer to in terms of the practice, what's happening? I don't know if it's very one for one every site, but just as a reference, you can, I think somehow I missed the whole conservative analysis part of it. I was just looking by what the SECRA standard is. So maybe in your statement, you can kind of call that out.
Sure,
that
absolutely.
As per the conservative analysis, this is a maximum, but based on what ITC standard is and based on what some of similar sites conditions, the projection is much higher.
Right. And we do expect, because for seeker, that's typically based for, rates associated with city operations. But, this site it's essentially bordering Nassau County. So, in anywhere else in New York, we would be applicable to use ITE standards. So, I do think we we anticipate and believe that IT would be an applicable, industry standard here. So that is what we expect. But yeah, we will certainly update our reports to reflect that.
Okay.
And then since we still have Demi here, we know the community board comments, and she will discuss a second about how we can reach out to DOT to address their concerns.
Oh yeah, so yeah, so in terms of the on-street parking, the community board requested that we prohibit on-street parking along the frontages. And, we certainly don't have any objection to that. As Elise mentioned, we can certainly initiate that conversation with DOT. That just requires us sort of putting together a signage plan of where we want to prohibit parking and contacting the borough engineer. So, we can certainly initiate that process, but, ultimately that's up to the discretion of DOT. So we will need DOT approval for that to actually be implemented.
And would that be done while you're undergoing the review at DOT, or would that be post-construction?
We can get that process started now, so it could happen during the initial review.
Yeah, Ms. Benke?
Yeah, I was thinking when you respond to the latest DOT letter, you could also share the community board letter and whatever you want to, however you want to respond to that as well. And we'll give them a heads up.
Yeah, I think you should incorporate in the analysis as you're. Okay.
Absolutely.
Okay, great. So the next question is about the wall. We looked at a survey and we believe it's probably ours, but we will confirm that. And we will also have an engineer confirm that it is structurally sound. And then the next kind of that goes with that comment is about fencing. So Tom is here to discuss what kind of fencing you would like to see around the site. And we can, after we have that discussion, we will make the plans clearer with whatever types of fencing.
To the wall, at least, I think Vice Chair mentioned, can you extend the wall? Isn't that
Well, that's why we're going to talk about fencing versus wall. What are our options here?
Sorry.
Can I ask the question in a different way? The proposed one-story building, and I know this is not within our purview, but the reason I'm asking is more because of where the driveway is located in relation to lots 114 and lot 112. It's right next to it, and the wall therefore also comes into the question. If you were to make the building footprint a little bit narrower, because there is so much of green space behind that building, you could pull that driveway a little bit in. Is that possible? I know each building operation has a very standard footprint of what you can or cannot, and would that work, and would that help the situation? And would you still be able to maintain 15 your queuing space and all the turning radii and everything?
May I speak to that?
Yes, this is for you.
Sure. So yeah, as you can see, we chose to go with the queue towards the back because of the linear aspect of that, to obviously maximize queuing, which is the goal of any drive-through restaurant. And we do have a constraint there because it isn't a super wide lot. So if we shrink that building, it's going to be hard to maintain that 20-foot radius at the back of the site on that curve. Kind of where the menu boards are, and that radius is so you're not dealing with, when you have like a
Mr. Whitney, all of a sudden your sound just dropped all of a sudden. Can you
is there something blocking your microphone?
No.
Yeah.
Yeah, sorry, it just kind of went like on to 50% all of a sudden.
Can you hear me now better?
Yeah.
Yes.
Okay.
Yeah.
So where was I? All right. So obviously, if we want to try to maintain that 20-foot radius, that's a standard Starbucks sticks with, because it's for an easy turn there. So people are, have a habit of kind of falling out of the drive-through lane sometimes in drive-through restaurants. And because it's a constrained lot, they wanted to maintain that radius to make sure there's safety on the site, and that people progress without, jumping a curb, since there were other buildings in close proximity and the retaining wall. They thought that was important. So we're a little hesitant. If we shrink the building, we'd probably still end up with the lanes kind of in the same spots because of that radius, because it is quite tight. So we could take a look at what we were thinking of doing is, because the grade does drop off on lot 114 and lot 12, it's not as high as the current lots that have the retaining wall. What we would probably do there is put fencing in to screen. We could do a solid surface. Right now it's called out as a white vinyl. And we can increase that height if the board wants to give more screening to those lots above 6 feet. We could look at what is permissible by zoning code, or if you want something higher than that, we can do that too. But to screen it that way, because building the retaining wall, then that gets into regrading those lots and other things, in addition just to the expense of the wall. It starts kind of multiplying cost-wise as to how you provide that screening, and whether those people, when those lots do get built, even want that regrading, who knows? So right now it's just sort of two vacant lots that are sort of, I believe have grass on it right now, but so that's why we went with fencing in that area.
The reason yes, based on the survey, the grade elevation of lots 114 and lots 114 and 112 is lower than the other lots, but the frontage of it, it fronts on 241st Street or Avenue, which is at a much higher elevation. So if that is going the main entryway, you will end up having like a situation where you have a cellar or a basement kind of situation, and then the first floor will be at street level at a minimum, at least, if not higher. So a 6 foot high wall is not going to do it. It will look like a 3 foot maybe high wall from the residential lot.
Right. If you're standing on the sidewalk at 241st, it's below you. I hear what you're saying.
Right. So it has to be high enough to provide that much of security, similar to what height you have for the I see Commissioner Shetta's hand up. Give me 1 minute, please. That's why the height of the fence has to be increased along the entire edge, not just along the rear, but along the side also, because there also it's going to be raised, right? And even though that's not in our purview, but for consistency and for your neighborhood's nicetiness and goodness, you should raise it up.
Okay. So we'll look at fencing options that give us something solid, but try to go for something that gives us about a 6 feet clearance from the sidewalk elevation of 241st Street. And we'll look what works.
At least 6 foot from the elevation of the 241st Street. That's a good way to go about it.
Okay.
But I would also I think even though the walk-up window, it doesn't generate much noise. It's the fact that the window is going to be open, and there'll be cars coming and stopping. And I don't know if a vinyl fence would be adequate in terms of the noise buffer. And that's why I was recommending that a similar 12 foot high concrete wall that you have existing be extended along the rear of 114 and 112.
Yeah, well, we're gonna look at the materials chosen. We'll try to find something, if we can't do that wall, something maybe that is a better sound barrier, something that might be more sound absorbing or something like that. So we'll take a look at it and try to find something that works for everybody.
Commissioner Shetta.
Thank you, Chair. Yeah, I was looking at spot elevations, and I noticed that you just mentioned some spot elevations at lot 114. I'm not sure if I do have the right survey, but I'm looking at page 2 of the PDF, and I'm not able to see any spot elevations there. Am I missing any of the drawings?
I was looking at the site survey that was provided, and I was using that to determine what is the elevation at 241st Street, which is, I think, at an elevation of 94, whereas the edge of the rear of lot 114 is 83. And
Is this a separate survey, or this is the survey that's in the drawings?
It's the survey that is in, it's a separate survey sheet that was submitted. Submitted on 5/6/2022.
Okay.
Am I reading it incorrectly?
I did look at it. I look at it, but I didn't see that.
No, the elevation is what? Elevation is 29.26. I'm sorry. And okay. And the other one is 23.38. So there is a drop from the front of 241, which is at elevation of 29.26. It drops to about 23. Yep.
Yeah, I see. I just opened that survey.
Yeah. So that's a significant drop. So I think maintaining at least a height of 6 feet, I would say even more, to basically make sure that it's not visible from the rear yard and from the first floor.
I would say the construction today is much easier than like next after that building, that lot got developed. It's going to be very tough to install a retaining wall there. So
29.
Yeah.
Yeah, so you're going to come to the same height as
You went out.
the existing retail, which is 12 foot high, right? Math is not good. So if you maintain a minimum 6 foot high to match 9, you would end up having close to a 12 feet, if not more. From
Yeah, I
your
see that
property line.
I can see that the elevation at the subject lot is about 23, and it's more or less, it's 20. Yeah, I would say it's about 23.
Yeah,
almost flat. But
yeah,
yeah, I see the elevation on the other side at the the other street parallel to Broadway. It's 29 all the way at the top.
Mhm.
And then it should be dropping, but I don't see a spot elevation at the corner. But so I'm not sure.
I'm assuming it'll be close to 23 feet or something. The bottom line is, I think Mr. Whitney gets it.
Yeah, I do. So we'll try to find something to try to, you're looking for us to try to continue that line with whatever fencing or screening that we put up. And we'll look at options that are maybe sound deadening that would help that. So those residential lots where they develop have a better experience moving forward.
Yes, thank you. Thank you.
And to continue on sound, Commissioner Shetta was correct. We do have I believe it's called the AVC, right?
Yes.
And so we're just confirming that yes, does exist. So that should help also with sound.
It's gonna stay like on for the whole like operation time.
Say that again.
It's gonna stay on. Okay.
Yeah.
So just put a note, if you can please put a note on the plan about the AVC, and that can be also part of the condition.
Yep. Thank you.
Problem. And then so I'll continue with the next set of comments. Okay, so the signs that customers should lower radio volume and no honking, that's not a problem. That's an easy fix. Pedestrian crossway should be painted yellow. That is also an easy fix. the detail of the aluminum fence. Tom, did you find where that was or what that was?
I saw it in the plan. I think in the, where did I see it? In the, it's in sheet number 008.
Yeah, we're gonna clarify, and we're probably gonna be changing up some of these materials anyway, so we'll call out much clearer where we're using things. I think the intention, and maybe we want to talk to you guys about it right now, is if you want some fencing along Brookville Boulevard there, just to kind of keep people from cutting across. So that's probably where we were intending it, just so there's a little barrier there to try to keep people out of the line of traffic. So, and also not make the site feel closed off or walled off,
That's what I thought, but I couldn't make it out from the site plan, and that makes sense. And that also goes to what DOT was saying, that they remove the curb cut, but it also provides a safety, pedestrian safety, in terms not mingling with the drive-through.
So you're good on that, Tom, right?
Yep.
Okay, great. Then I will keep moving. So the next big issue is the trash enclosure, and could it be moved? Do you want to speak to why we put it where we put it, and then we'll have a conversation about it?
Yeah, and trust us, we've tried to put it everywhere. So it did move around the site quite a bit. One of the key tenets here is obviously we didn't want the trash to be along the street. We wanted this development to improve the street edge of the property. So we did keep away from any sort of sidewalk boundary to keep the site open and looking good. We also have to consider, originally we had some additional curb cuts. We worked with DOT and the community board and came up with the scheme we have here for what works for the site, but we need to be in proximity to that curb cut for ease of a truck coming in, grabbing the trash and getting off as quickly as possible and as easy as possible. Basically, this location here was chosen for that proximity, and also to keep it away from the street edges so that it's not against the pedestrian right-of-ways of the sidewalks. And that's kind of how we chose it. The plantings that we plan to do between it and the property line would be a larger specimen of an evergreen, not a low planting. And so there would be something like an arborvitae or something to that effect that will grow and actually help screen it a bit more. So we can call that out maybe a little clearer in the plan for that planting screening, either a variety or something that gets it maybe more specific. But that's how we got to the trash where it.
And I would say you should continue with that fence treatment along the rear to the side. Visually it looks nice. Otherwise, you have too many materials within the same area. But that will also add to additional buffer in terms of noise and visual.
And I just want to say my concern was the rodents that usually accompany trash and trash enclosures. So if you can be mindful of kind of rodent treatment and have them regularly so that this does not back up into the lot behind it, which is right now vacant, but at some point somebody may want to put a house on it.
Mm-hmm.
Someone had mentioned that cedar is actually a good rodent repellent. So I'm not an expert on this, just look into it and see what are the ways you can approach it and an operational plan that will ensure that. But that's not what is before us, but it's just something as a good neighbor you should look into.
Understood. And then we can put the physical distance from the menu board to the residence. That's not a problem. Commissioner Shetta, now that you found that survey, are you satisfied with the survey? Okay, thank you. And then lastly, we do know about those.
Somebody froze. My screen froze. Was it just me? Probably you.
Yes,
Yeah.
it was you, Madam Vice Chair.
So
Sorry.
all I said was, are you good with the survey? And I saw him nod.
Yes, I said yes.
Okay. And then the next or the last comment I have, unless I'll missing something, which I might be, is the shielding and lighting. We do know those two spaces where you highlighted it. We're going to look into shielding options so we can lower in those two locations the lighting output. If anyone wants to add anything on that, please feel free.
Yeah, we heard all your comments, so we will look into shielding options, and if they are not sufficient, we'll look into lowering the lighting as a secondary option if that is what gets us to the goal.
Right. Okay. Yeah, I mean, if you have a 12-foot high wall, and I don't think you need a light post that needs to be taller than that.
I think you mentioned limited to 10.
15 feet or something, and then
I think it's 10.
if you put it in, these are actually how many feet? 20, 22, 20, about 40 feet or something apart, right?
Mm-hmm. I'm just looking at the detail.
So if they're close to each other, they don't need that many. Don't need the lamp post to be high. That's another way of going. Then they can be. Oops.
Vice Chair, you're freezing. There's something
Hi,
weird's
did I?
happening there. Yeah, you froze, but we could hear you
Something
speaking.
weird. As long as you can hear me
Can you
speaking,
say the
that's
lamp,
good enough. You don't need to
the
see my
lamp
face.
post thing one more time, because I didn't fully hear that.
Yeah, so the lamp posting right now, the distance between the two lamp posts, especially along the rear lot, if you reduce that, maybe your lamp post height does not have to be too high. It can be lower, and that would be another way of shielding it from the residents. And then you provide a little bit of shield to angle it just towards the driveway.
Okay.
Commissioner Yoon, Commissioner Yoon is looking into this also, so that's why I'm asking Commissioner Yoon on this.
All right, Vice Chair Chanda, can you repeat that last question?
I had suggested that reducing the height of the lamppost and providing maybe some in close, more frequently. Instead of 2 in the rear, maybe you can have 3. That way you could have them at a lower height and can have all the coverage that you need. And that can also result in more shielding.
That's an option. I mean, I'm not a lighting expert, but of course, when you're trying to create a safe zone at night, you usually use taller to create more spread in the areas that you need the light. So however, I think in any case, what we're looking for, our intent is just to prevent any leakage over to the adjacent properties. So if that's using taller fixtures that have shields or glare prevention, or lower fixtures more frequently to provide a safe environment for the customers, I think either way, we're just looking to protect the adjacent properties.
We understand, and we'll try to make that clearer in the next revision. Maybe put a lighting detail on the plan so you can see what we're proposing.
Great.
Thank you. Thank you, Commissioner Yoon.
I think that is all the comments, I think.
Okay. Any other comments from the commissioners? Then we can go to the public. Did we pick up all the questions?
Seems like it, yep.
Yep. Okay. Let's go to the public, please.
So the case we're currently discussing is 2021-69 BC. This is a special permit for accessory drive-through to a Starbucks, right? Should you wish to discuss, dial 646-558-8656, enter webinar ID number 834-2722-0881, and you'll press the pound sign. At the next prompt, you will press the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute to speak on the phone. And if you're in the Zoom room already, please raise your Zoom hand. And that is the hand that is on the bottom of the screen. Excuse me.
So I think the big question is DOT. How long will it take for DOT to complete its review and all the, I think there's quite an extensive set of comments DOT has.
Demi, how long to respond, do you think, to those questions?
Once we get the updated plan from Tom, it shouldn't take that long. You know, most of their comments were just small technical comments for updating our analysis. That shouldn't take, you know, considerable amount of time. Yeah, I guess a couple, maybe 2 weeks to probably get it in.
Okay, cool. And then Tom, how long do you think you need to look at that? Because I know you have to look into a few things like fencing.
Yeah, I have to look into some fencing options. Definitely need a few weeks to make sure we make a right decision that works for everybody.
I mean, so I guess a few weeks for that, and then a few weeks for the architect, and then after that, maybe like 2 weeks for Demi to finish up her stuff, and then however long it takes DOT to get back to us. That's the timeline. Carlo is raising his hand.
Carlo has his hand up.
Yeah, I can't see.
Yes.
Because of I can't see. Yeah, go ahead.
I mean, I could suggest, you know, putting it out a little further in an effort to avert an extra hearing. You know, to have the submission, to submit to DOT, give DOT time. So, I mean, we could look at November 14th, 15th.
That's what I was thinking.
The submission for the application would be October 25th, but obviously the quicker you get the materials in for DOT, the quicker we can try to turn around.
I think that sounds great.
Okay,
Do
thank
you
you.
guys agree? Because it's not just my work.
I think so.
Yeah, that works.
Yeah, I mean, I could put it on earlier, but if we're not there yet, we're just gonna waste the hearing.
That makes total sense. I think that's a perfect plan.
Thank you.
Okay. We didn't hear back from anybody, so, all right. So it would be scheduled for November 14th hearing.
Sounds great. Thank you.
Thank you. Have a good evening, everybody.
You too.
Thank you for your time.
Thanks, everyone.
Bye.
Yeah, the final case is item number 36, 2021 70BZ, 1206 East 21st Street, Brooklyn.
All right, I think this is Mr. Goldstein.
Goldstein.
How are you?
All by yourself?
Yes, ma'am.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Please state your name and proceed.
Good afternoon, Jay Goldstein for the applicant. So attended the review session. I heard the comments. Madam Vice Chair, if I may, in response to your comments, I'd like to share the screen for 1 second. I don't know if I have those abilities. So I will share my screen and let me know if you see the pictures.
Yes, I do.
Okay. The request was made, and I apologize that the 50% thing was not caught. I don't know how we missed it after all these years, but we, in an effort to achieve 50% retention, Madam Vice Chair, you mentioned perhaps pulling the front of the house back at the second floor. The design of the house and the whole concept behind the design that was there is for that large atrium, the double height atrium. So Madam Vice Chair, you mentioned that the block has a, you know, somewhat of a feel of everyone has these setback second floors. So we have the photographs. These are the photographs that were submitted to the board. I just want to point out that the house directly across the street, which I've circled now, has the second floor as flush. The house that's circled over there is two doors over, which is a corner house, but it has a large second floor presence on East 21st Street. This is directly across the street. Again, a large second story addition flush with the first floor. And this is directly across the street where there is a slight, you know, the gray house has a slight setback at the second floor, but it definitely is not the same design for all the houses. And that's really the point. So in looking at the case and analyzing how I can figure out a way to get the 50% retention while trying to retain that front yard, I noticed this circle area that's the area that I circled. This is the second floor. There's like a closet over here. We can easily remove portion of that closet or all of that closet to retain the extra 6 feet that we're missing, that would bring us to about 52%. That would get us to the retention rate that the board sees. That would also allow us to maintain the front of the house, so that we do get to keep the design that was anticipated. The whole building was designed around that double height atrium when you walk in. So I do believe that there's an easy way for me to come up to the 50, to meet or exceed the 50% retention. But in doing so, I do ask that we be able to keep the front yard as proposed.
Okay, so even if I were to say you can extend a little bit into the rear in order to set the second floor back, that's not something your client would be willing to do.
It's not a matter of willing, it's a matter of when you walk in that front door, if we're setting the second floor back, you would walk into a 1-story atrium instead of this 2-story atrium. So it would significantly impact the design of the house, and it would almost take us back to the drawing board for that house.
Okay.
Most of the houses that we see where we're saying we'll pull back, it's because they have more bedrooms proposed at the second floor, so it's easier just to shift everything back. Here, it's very difficult to do that, but I do think that the block has enough variety in the houses, especially the corner houses that are right next to us, that we can justify the 2-story addition that we're proposing.
Okay, all right.
So assuming I can get to 50%, if you're okay with it, Madam Vice Chair, and the rest of the commissioners are okay, I'd appreciate that.
Yeah, if you, I guess that's the only threshold factor. None of the commissioners had an issue with the rest of the design. So,
right. And just Commissioner Shetta asked me to add the dimension at the section and elevation. We can do that as well.
Okay.
Thank you.
Thank you. Let's, any other comments from any of the commissioners? None, sideways shake. Let's go to the public.
Okay, the case that we are discussing is 2021 70BZ 1206 East 21st Street, Brooklyn. This is a special permit application to permit the enlargement of a one-family residence. Should you wish to discuss, please dial 646-558-8656, enter the webinar ID number 834-2722-0881, and press pound sign. At the next prompt, press the pound sign. Once you are in the room, press *9 to raise your hand, *6 to unmute to speak. If you're in the Zoom room already, please raise your Zoom hand, and that's the little hand at the bottom of your screen.
All right.
Time.
So how long will it take for you to revise it? You know, we don't have September.
I was going to ask anyways, just, unless I can get on the October 3rd calendar, which I know is booked, I'd have to wait till November, just because of the holidays.
We will look
into 1 second. Let me look into it. 1 second.
Okay.
We can do October 3rd.
Okay, great. So I mean, my math says that if I get 6 additional feet, I'm at 51%. If you look at am I still screen sharing or no?
No.
Okay, so when you allow screen sharing again, I pull something up. Am I able to?
Yeah, yes.
Yeah.
Okay. So my math says that if I get 6 additional feet, I'm at about 51%. This line over here, the 3 foot, and then this additional line of 3 foot is the existing building line. So I can easily amend this corner to meet that line.
Okay.
So I'm confident that I'll get the 51% or over 50%. Given that it is a minor change to the plans, and I would ask if possible if we can close the hearing.
Just because I know you do things absolutely what you say, and you know what we're asking for, And this is a minor change. I will be okay with closing it, but, and then you'll be making this correction and we will then make that a decision hearing. Is that okay?
That's why I
Does
just
that
want to be
for
sure.
our-
Yeah, my math is correct, I believe, so. So I'm confident in saying that to you.
General Counsel Vine.
I'm okay with it. It's just at the risk to Mr. Goldstein. If it turns out that it can't be done, then, you know, we'll only be reopening on that date.
Understood.
Okay, all right. Let's do that. So motion to close?
Can you stop sharing the screen, please?
Sure.
So I can see everyone when I do the poll?
If I could figure it out, sure. Give me 1 sec. I don't know how to do that.
Just click stop share. It's supposed to
No, I
show
know,
full
there's
screen.
no, it's not popping up. It's not giving me the options. So can the moderator kill it? Yeah. Oh, there we go.
go. Okay. So we're calling a motion to close. Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Wait, can we redo that, Commissioner Shetta?
Sure. Aye.
Commissioner Shabeta?
Aye.
Again?
Aye.
Thank you. Commissioner Yoon?
Abstain.
Thank you.
All right, thank you very
Right.
much, everybody. Have a great rest of your summer.
Thank you.
Okay, thank you.
Everybody, have a great summer.
This concludes the public hearing for August 9th, 2022.
Okay, thank you. Have a great summer. See you in September.
Bye,
And
everyone.
I'll send an